All rise. All persons having business before the Honorable Chief Judge and Associate Judges now sitting en banc for the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. We're here this morning to hear en banc the matter of Brian Moore versus United States. We're joined by amici, the Public Defender Service, who will be arguing for part of the appellant's time, and the District of Columbia, Office of the Attorney General, that will be arguing and sharing some of the government, United States time. The matter this morning deals with the scope of the attorney-client privilege and whether the significant purposes test applies permissively in the context of relationships between attorneys and defendants. Should the court focus on whether the purpose of the threat was to obtain legal advice, or should it focus on whether the significant purposes of the general communication was to obtain legal advice at the time the threats were uttered? The panel in the case below, the majority reversed the convictions of the appellant, holding that his statements were protected by the attorney-client privilege and therefore inadmissible at trial. The dissent argued that the appellant's statements were not protected by the privilege because Mr. Moore did not utter them in furtherance of obtaining legal advice. So we look forward to hearing the arguments of the parties today. The appellants have 45 minutes. How would you like to divide the time with the amicus Public Defender Service?
Your Honor, we're going to reserve 5 minutes for rebuttal and 40 minutes, 15 minutes will be ceded to rebuttal.
All right, thank you. And with respect to the government, how would you like to divide the time?
Your Honor, we will cede 10 minutes our time to the Office of Attorney General.
All right, thank you. Counsel, are you ready to proceed? I should say, joined by our full court of active judges. And I think our nameplates are large enough today so everyone can see them. Normally, I would introduce the whole panel. To my far left, far right is Judge Howard. Next is Judge McLeese. On my immediate right is Judge Beckwith. To my left, immediate left is Judge Easterly, Judge Deal, and then Judge Schenker on the far left. So good morning, and counsel, if you're ready to begin, we can proceed.
Please the court, Sean Day on behalf of Brian Moore. The third Wigmore element of the attorney-client privilege is that the communication must relate to the purposes of the representation. The issue for the court is how broad or narrow is the requirement that the communication must relate to the representation, keeping in mind the interests served by the privilege. The focus is not really on the first Wigmore element, which is something that the government has misinterpreted. The first element is merely that legal advice has been sought, which is helpful for trying to determine whether or not there is, in fact, an attorney-client relationship to begin with. The government's interpretation is that the communication must itself be in pursuit of legal advice, but that would make the third element irrelevant. And even the client is reciting the facts of the case. That is not a request for legal advice. It is a communication relating to the purposes of the legal representation. And in determining whether or not the communication relates to the representation, courts should not examine the communications in piecemeal fashion, line by line. They should not, with scholarly hindsight, analyze each comment. Clients are often in high stress environments, adversarial environments. It can be frustrating, can be foreign. In many cases, you have clients who are not eloquent or restrained in communication, may have mental health struggles.
May I interject? If we were in agreement that the relationship and communication shared within the attorney-client privilege should be reviewed broadly at sort of a high level within the context of the relationship, does that mean there would never be any statements or confidences revealed that could not be disclosable, number one, and even at some point might warrant going outside the attorney-client privilege relationship? And I say disclosable under Rule 1.6C, and then testifiable, as we had here, outside of the attorney-client privilege. In other words, is it absolute? Can you never look at something that occurs within that relationship and say, even if we view this broadly, this was inappropriate and perhaps illegal?
I think the test is whether or not it relates to the representation, which is viewed very broadly in Maryland.
Right, I understand the relates to the representation, but does any and everything that is ever and always said always relate to the representation? And how do we draw that line here?
I would say probably not absolute, but incredibly broad. For instance, in the Newman case in Maryland, you had a custody dispute and the parent threatens to kill the children and frame the husband. Okay, it is a custody dispute, it's a domestic dispute, and the communication obviously relates to that subject matter. You have Purcell in Massachusetts, the person's facing eviction and threatens to just burn down the whole occupied building. You have situations like that where just obviously relating to the communication. If
So
you
what if Mr. Moore had come out, had said, I need to speak to my lawyer, goes out, talks to Mr. Harvey and says, I'm going to shoot the prosecutor. And Mr. Harvey says, what are you talking about? That's a terrible idea. You shouldn't do that. She's just trying to do her job. And Mr. Moore says, has nothing to do with this case. She stole my parking space this morning. Is that covered?
In that scenario, it sounds like it would not be. It gets a little fuzzy. I'm a little confused because she is the prosecutor in his case and he's just seeing her now, and I would explore whether or not it in some way relates to the case. But if it's totally unrelated, if it's an incident of road rage or something else, unless the client somehow connects it to representation, like, hey, you know.
How is the threat here in this case where the client threatened to shoot the prosecutor in the case, who was right inside the courtroom when he stepped outside? How is that threat, which under our law would be a complete crime in of itself, how is that related to the representation? In what context? He didn't ask his attorney, should I shoot her? Because I'm really mad. He said, I'm going to do this. How would you relate that? Even though I agree with you that we need to take a broad view of confidences, shared communications between lawyers and clients.
This is the prosecutor who was prosecuting him in this case and causing Mr. Moore some grief in this case, trying to get him detained pre-trial. He's frustrated about the situation, frustrated with the actions of the prosecutor. And this is an ineloquent communication from the client, giving clients breathing room to say things that, as the appellate court in Kansas said, even if it seems jarring in isolation, you have to give them breathing room to communicate about this case.
So counsel, your answer seems to be more that this wasn't a threat. And I think the question was, if there was a threat, then why isn't that And you also seem to answer in response to Judge Easterly's question that you can parse out some statements that might not relate to the scope of the representation. And so if the answer is not that this just wasn't a threat, then why isn't that parsable? The threat that the chief judge just mentioned.
I'm taking in the question that it was a threat. But what I'm saying is it's a threat that's linked very closely to the confines of the case. They have a break from the case. Mr. Moore is angry about what the prosecutor is doing to him and is communicating to his attorney about the prosecutor and about the developments in the case and the prosecutor is doing to him. He expresses it allegedly in the form of a threat, but it is still a communication that relates to the representation.
Right, so I guess my point is that the fact that this was perhaps ineloquent or venting is not really your answer, right? I mean, are you proceeding on the presumption that this was a threat?
I think for the purpose of today, the presumption is that it is a threat.
Can I ask you another question about what you're disputing and what you're not? Are you, for purposes of the argument today and the resolution of this case, disputing whether Mr. Harvey's disclosure to the judge was consistent with the requirements of Professional Conduct Rule 1.6C1?
Yeah, right. Those are two different issues.
I understand you
Right.
think they're certainly different. They may be related in complicated ways, but I'm just trying to figure out whether you're disputing that disclosure was consistent with the requirements of 1.6C1.
Right. And another view of that is that he did not disclose it pursuant to 1.6, but he disclosed it because he was ordered to disclose it by the judge. But
Understood,
either way,
which is why I asked my question, not about whether he disclosed it under Rule 1.6C1, but rather whether his disclosure was consistent with the requirements of Rule 1.6C1.
right. That's not an issue.
You're not disputing that.
That's correct. The question is whether or not it retains the privilege. And this court, in fact, and other courts have held consistently that the rules of professional conduct that allow disclosure do not waive the privilege. These are separate
Well,
considerations.
I think courts are somewhat inconsistent about that in some ways, but so let me just ask you why I think they might be related, and I'm interested in your response. So one of the other requirements of the privilege, as it's sometimes stated, is stated various ways, is that the matter be at issue be a confidence. And so I assume you would agree that if the statement here had been not just said to Mr. Harvey in the hallway, but had been said like in the courtroom with a lot of people around, you would not think of that as covered by the privilege. And in theory, the attorney could be required to testify to it among others because that just wouldn't be in confidence.
Correct.
And I guess where I start wondering about the connection between the ethical rule and that requirement is if the ethical rule is lawful as not contradicting the privilege, so it's not a violation of the privilege to disclose this as well as being ethical conduct, then why would a reasonable person be entitled to expect that statements covered by the ethical rule, that would be statements that a lawyer could reasonably conclude need to be disclosed to prevent a criminal act that the lawyer reasonably believes is likely to result in death or substantially bodily harm, why would those be viewed as confidences or confidential? Because why would a reasonable person expect that they would be kept confidential? The ethical rules say it's ethical for the lawyer to do it. And if that ethical rule is not itself a violation of the privilege, it's also consistent with the privilege to do it. So how would you think it's confidential? How would a reasonable person think that was confidential?
I believe the reasoning is that the privilege belongs to the client. And the rules that allow the attorney to disclose certain threats are based upon the subjective belief of the attorney. May be unreasonable, just the subjective belief of the attorney that this is what I believe.
Well, I don't think that's quite right about the rule. Sorry to interrupt, but the rule for disclosure to be lawful under the rule, to be ethical under the rule, leave aside what that means about whether it's lawful under the privilege, but to be ethical under the rule, the lawyer has to, it has to be reasonably necessary for the lawyer to disclose. So I don't think it's purely a subjective inquiry into the rule. If I am a lawyer and I have no reason to believe this, but I start, spilling my client's privileges and claim the rule, even if I'm doing that in good faith, I'll be acting unethically. I probably will be violating the privilege too. So
I still think it requires a determination by the attorney. It's a discretionary decision by the attorney to disclose or not disclose. And I don't know that the client can get inside the mind of the attorney to decide, what the attorney is going to think is a reasonable, necessary disclosure. I also,
And just leaving aside the rule for a minute, just stepping back even more abstractly, forget about the rule. If it is a requirement for something to be privileged, that the client reasonably believe that the statement would be kept confidential, why would you say a client could reasonably believe that a statement threatening to shoot somebody would be kept confidential? Why wouldn't a reasonable person think, well, it's not going to be kept confidential? Someone's quite likely to disclose that. Just as a matter, leave aside the rule, just as a matter of what's reasonable to believe. I mean, if to take a worse scenario, if you're representing me and in the midst of it, I'm angry and in connection with what's going on, so related in some senses, I say, I have access to bomb making materials. I'm going to blow up the court tomorrow. Would you say that I would be able to objectively, reasonably believe you're going to keep that confidential, or would a reasonable person in my situation be charged with understanding that, of course, that's not going to be kept confidential? You're going to tell someone. You'd have to tell someone. The rule reflects the idea that it's ethical for you to do that, but wouldn't just a reasonable person think, yeah, of course, that's going to be disclosed?
I think the attorney still is going to be making assessments about the seriousness and the credibility of the threats, the attorney's decision. And again, the courts have decided this issue, and including this, panel decision in this court, is that they are not linked. You've got one that's a evidentiary rule, privilege rule, and the other is an attorney ethical rule about when an attorney can disclose something in it. And we have set up this safety for the attorney to be able to do that without breaching the privilege. And I would say that this also serves the public interest.
So you agree, it sounded like you just agreed that not only is it ethical under the rule for an attorney to do that if its requirements are met to disclose, if the requirements of 1.61 are met, but you agree that's not a breach of the privilege. That disclosure is not a violation of the privilege. It's not only
That's
ethical under
correct.
the ethical rules, but it's not a violation of the privilege.
It's disconnected from the privilege is what I would say. And that it works in conjunction with the privilege to provide attorneys a safe space to be able to make these disclosures without harming the client. Attorneys are already reluctant.
Well, how would it not harm the client? I mean, I would think if you made a disclosure, I guess it depends on what you think the limits are on what happens after such a disclosure is made. So, let's say in the hypothetical about having bomb making materials and blowing up the courthouse, imagine the disclosure is made under 1.6D1 of that kind. And imagine that you're right, that doesn't mean anything about what the defense attorney can be required to do by way of testimony. That's a whole different topic if that were true. It still could be very damaging to me as the client, I guess, for you to reveal that. Let's say they go to my house and find the bomb making materials and, all sorts of bad things happen to me arising out of that. It might be that depending on what you think can be done with it, maybe that that's used to revoke my release in the case at issue without requiring you to testify. So it seems like it still could be, that disclosure could be very damaging to the client.
It could be, and I think that's why attorneys are, even with these protections, are going to be reluctant because are you ever really, how sure can you be? But I think there's a big difference between setting things in motion for law enforcement to investigate and being put on the stand and having to testify against your client about, communications that the client.
Can I ask you about the other side? Using the same hypothetical that Judge McLeese just shared about client threatening to build a bomb. How would you analyze that on the privilege side, the attorney-client privilege side under our case law?
Well, I guess it depends on how it relates to the case.
Okay.
If you say, "Hey, attorney, I'm just happen to be building a bomb and I'm thinking about
No,
doing this."
if we'll say it's within the confines of the, okay, I guess this is a follow-up to my question about where are the parameters, if any, on when you can go outside the attorney-client privilege? And using that same hypothetical that Judge McLeese just gave, how would you would argue that the lawyer still couldn't step outside of, waive, breach, whatever the language is, the privilege itself, even after having made the disclosures under 1.6. And that is because even in this kind of scenario where you have a threat or a crime or completed crime, how would you complete the rest of that analysis?
Well, I think the privilege remains if the communication in some way, loosely viewing it, relates to the representation. So it would depend on, and like in the Massachusetts case of Purcell, The client's being evicted and he's just angry about the eviction, so I'm gonna burn down the building. It's a jarring in isolation, but it is a communication that did relate to the case that he was consulting with the attorney over.
So,
Go ahead, sorry.
counsel, if in this case, Mr. Moore and Mr. Harvey had been in an isolated part of the courthouse, no one else was around, conversation was admitted, and it was definitely about the case. And instead of Mr. Moore saying, I'm going to shoot the prosecutor, he actually pulled out a gun and shot the prosecutor in front of Mr. Harvey. No one else saw it. Would the act of that shooting be privileged?
No, because that's not a communication. That's an action that the attorney observes. I
Right.
think we have, when you have, the thing about threats that makes it different is threats are pure communications. to the
Well, are
attorney.
they pure communications or are they acts that are affected through the use of communication? I mean, I thought earlier you said that you were proceeding on the assumption that this was a completed crime. And so how a completed threats crime? So how is that distinguishable from any other completed crime?
Because it is, the completed crime and the communication are one and the same.
Can I ask you a hypothetical, a variant of Judge Shanker's hypothetical? Imagine that exactly his hypothetical, except so the client says to the defense attorney, I'm going to shoot, I'm going to kill the person. And then the client takes out a gun and shoots and misses. And so I understand you to acknowledge that the defense attorney could be called to the stand to say, yeah, I saw my client pull out a gun and shoot towards the victim. But you would say that the defense attorney would not be allowed to recount the statement that might be relevant to intent to kill. If that was the charge, assault with intent to kill, I'm going to kill the person. That would be, on your view, excluded. That would, the non-communicative conduct would be in, but the related language that would be relevant to what the intent was would be excluded. Is that how you?
That's
would
correct.
analyze it?
And that's
Is your answer the same if what the client says is, I'm about to shoot the prosecutor, counselor, but if you wouldn't mind advising me on the best place to stand so that I'm not caught by the court's, cameras, that would be great. Would that be covered by the crime fraud exception?
You were right. That is seeking advice for the purpose of committing a crime. So that is something that does fit within the crime fraud exception.
Isn't that horribly odd to think that if I say I'm going to shoot the prosecutor, that's a communication that's privileged? But if I ask for advice, and my counselor says, I'm not giving you anything, don't do that. So I disregard your advice, I'm going to do it anyway. The first half of that, seeking advice, where should I stand when I shoot the prosecutor, would be accepted by this crime fraud exception. But if he's just phrased it slightly differently without seeking legal advice at all, which is kind of the core of what this privilege is supposed to protect, is seeking advice, but suddenly it doesn't protect the seeking of advice when it relates to a crime, but it does protect not seeking advice at all, provided that it is talking about a forthcoming crime. I don't understand how that line makes any sense.
Well, I think the crime fraud exception is because the client is using the attorney to assist and aid and abet in the commission of a crime as opposed to just getting. But
It's not the test you put in your brief, though. I don't think does anything depend, in your view, on the attorney being complicit in the scheme?
Well, I would say that the crime fraud exception is interpreted by this court in other cases. It's even more narrow than that, because if the attorney counsels the client against the actions, then the crime fraud exception does not apply.
Well, at least if he successfully counsels.
I
What case do you have? So, In re PDS says, if the client comes to the attorney with a scheme and the attorney nips it in the bud, quashes the scheme, then that's still covered by the attorney-client privilege. What case do you have that says if somebody comes to the attorney with a scheme, attorney refuses to go along with it, and then the client goes ahead and does it anyway, that's still covered by attorney-client privilege and not the crime fraud exception? It's not the formulations that I'm seeing in your brief. The typical formulation that you have is, let's see, the attorney-client privilege does not extend to communications made for the purpose of getting advice for the commission of a fraud or crime. That's from Zolin, the Supreme Court case, which is kind of the typical formulation of it. It's not just and the attorney has gone along with it. You're seeking advice to do something illegal and then you're outside of the attorney-client privilege, or do you disagree with that view of the law?
Going back to the case, yeah, so actually it's a Third Circuit opinion, 2014, cited on page 32, note 16 of the brief, that just merely advising the client of the criminality of the conduct, if it does not assist the client, leaves the privilege intact.
Can I ask you about another a case not from this jurisdiction, but from the Supreme Court? And I'm wondering how the position that you're taking, and this is focused less on the idea that the statements of "I'm going to shoot the prosecutor" were a completed crime themselves of threats, but more as a statement of intent to commit a crime in the future. In Nix versus Whiteside, the Supreme Court said the following, and I'm just curious how you square your position with that quote. And you don't necessarily have to, because the Supreme Court has its view of the attorney-client privilege. We can have our own that would be different. But the quote was, an attorney's duty of confidentiality, ... does not extend to a client's announced plans to engage in future criminal conduct. So is your view inconsistent with that? And are you saying really we just should, strike our own course separate from what the Supreme Court thought in Nix? Or what's your response to that quote?
I don't believe there's any inconsistency at all, because I believe Nix is not a privileged case. I think Nix is an attorney ethical obligation case, in that it's the situation where the client is going to commit perjury, and what are the ethical obligations of the attorney? And I think the attorney is allowed to then advise the court that the client is committing perjury. But I don't think that was a privileged case. It was just about what an attorney may or may not do.
Well, I
What
mean,
an attorney must
again,
do.
it's the quote. I mean, I take your point that Nix might be factually distinguishable, and maybe one could argue it's dicta. So I get those lines of thought, but just the quote on its own terms is about the attorney's duty of confidentiality, which seems to be about the scope of the privilege. I would think, because one of the requirements of the privilege is that it be a confidence. So are you basically saying you think that language might be overbroad or might be dicta? Or if you take that, can you square it, your view, with that language? Leave aside whether you think you could distinguish the case in which language appears.
I would say it's not applicable to this case in deciding the privilege. I think it's just applicable to an attorney's ethical obligations when a client is or intends to commit perjury and a fraud upon the court, and that an attorney must intervene and can do so without violating the obligations of counsel or the Sixth Amendment right of a defendant to effective assistance of counsel. And I'm not sure, I believe Judge Deal
I was actually looking at the Third Circuit case that you cited me. So yeah, I think you answered my question.
Okay.
And counsel, in Swidler and Berlin, the Supreme Court said it was not aware of any authority that counsels in favor of a different application of the privilege in criminal and civil contexts. And again, as Judge McLeese said, we might not follow that, and the court was just saying it wasn't aware of any authority. But what's your view on how we should approach that?
I think Swidler was the tax return, the documents got in the possession of the attorney. The context is relevant. The context here is relevant. I don't think it's necessary in this case, because you do have a communication that relates to the representation. I don't think we need to go beyond that, but there are certainly considerations in deciding, what serves the public interest. You have an indigent client, you've got an attorney who is imposed upon him. He didn't go and do research, interview, select, and hire an attorney and have that kind of relationship. And so if we're going to foster a relationship where the client feels free to communicate with the attorney, we have to have an expansive view of the privilege that's going to protect. You want a client not to have guarded communications, but free and open communications. And that, I would say, despite their alarmist position on this, it serves the public interest because it allows an attorney to make the disclosures without fearing that the privilege will be breached and he's going to end up on the witness stand testifying against the client.
Yeah, but what good does that do anybody? Let's assume that your client was quite serious, that he was intent on shooting the prosecutor in this case. And Mr. Harvey can disclose it But there's no case against Mr. Moore because the statement can't be used. And let's say Mr. Moore takes it a further step and says, I'm going to shoot her. And I know you're going to tell the judge this, but I also know you can't use it against me. So once this blows over the initial heat from whatever you tell the judge, well, then I'm going to shoot her. How does that protect the public interest? What can you do with that information? I mean, I guess you could give her some marshals to protect her, but the threat remains quite imminent.
I think the alternative is nobody ever hears about the threat because the attorney is discouraged from, an attorney.
I mean, the other alternative is that they can prosecute him for crimes that he's committed in the presence of his lawyer.
I think these types of disclosures are very rare. Attorneys are reluctant to make them. Mr. Harvey was reluctant, only did so after being ordered to do so. He did not freely make the disclosure. And so I don't think you're going to have a lot of attorney. An attorney can go his or her entire career just assuming that threats are not serious and be right 99% of the time, I imagine.
That makes it all the more striking, though, this case, because, I take your point, people should be able to vent, they should be able to blow off steam. I suspect most criminal defense lawyers, when hearing most statements like this in what is relatively not, this is not a mafia hitman who's talking about shooting her. This is somebody who is not up on weapons charges or a gun crime. You might think, well, he's just blowing off steam. And Mr. Harvey accepted that answer after the first few statements in April. But then they come back and they happen again. And so it at least raised, he said in 30 years he had never done it before. I think there was some dispute in the record about whether or not that means he had never been forced by the court to report it, or if he had never previously gotten off a case because he was worried about a threat. But the fact that he is a pretty seasoned criminal defense attorney and thinks that Mr. Moore is serious and tells Mr. Moore before he says it again, I'm going to take you seriously if you say it again, all kind of counsels against this. People should be able to blow off steam perspective. That might be true. And Mr. Moore might have crossed that line, as a jury apparently concluded in convicting him.
Well, I think the record is mixed. Mr. Harvey did say that, but when he went up to talk to the judge, it was, if you order me to tell you, I'll tell you. And even on July 2nd, when he's talking with the judge, he said he hadn't told the prosecutor. He still felt that he could not freely disclose to the prosecutor, that he was still relying upon the fact that he had been ordered to disclose because he was really trying to get out of the case. And he testified before the grand jury and at trial. I was trying to get out of the case. And if I needed to make the disclosure to get out of the case, then that's what I was going to do. And the judge ordered him to make the disclosure. I think there's some question about whether or not, it didn't seem that Mr. Harvey was really relying upon his belief that it was a serious threat. It was more that I need to get out of the case.
You would, in the grand jury, which was an exhibit to the hearing on the eliminated motion, so it's part of the evidence and promise for this purpose, and also again a trial. I think less, but certainly and also in the transcripts of some of the proceedings when he was talking to the judge after both incidents, trying to get approval to withdraw. Mr. Harvey was very clear that he, in fact, took it seriously and gave very specific reasons about why. So are you suggesting there's some doubt about whether he believed that they were serious threats?
Well, when it came down to why he made the disclosures, Mr. Harvey never said he was relying upon Rule 1.6.
That's true, but that's not entirely a direct answer to the question I'm asking you, which is, are you arguing that the record is unclear about whether, in fact, he thought the threats were serious?
That's what he said. He said he thought that the threats were serious, but it was really about getting out of the case, that he had tensions with Mr. Moore and wanted to get out of the case. And that's why he made the disclosures.
Counsel, let me ask you before you move on. If Mr. Harvey took the threat so seriously, do you think that would have, considering the other duties of an attorney, implicated any kind of duty for him to go and make some more inquiry? Or was it just enough that the words were said at some point and he took it seriously and now he goes on?
Well, again, I think that's part of the problem with trying to waive the privilege based upon the belief of the attorney. Should the attorney have done more? he certainly could have. He certainly could have talked it through, like, hey, I know you, because this is all in the heat of the moment. This is not after Mr. Moore's calmed down. This is, he's on fire, he's hot, he's angry about what's going on in the court. And yeah, there could have been more probing by the attorney and it could go either way. You could, if you probe more, you find out it's not serious, or you probe more and you find out it really is serious. And that is another reason why it's important to maintain the privilege, because otherwise an attorney is going to shut down the conversation, because if you see a conversation going in a direction where you don't want it to go because you're going to hear something that is not going to be privileged, you're going to shut it down. It's better if the attorney develops a little more information. He continues talking about it, and preserving the privilege will serve that interest. I'll turn things over to Mr. Collins.
All right, thank you. And we'll reserve some of your rebuttal time as well.
Good morning, Your Honors. William Collins on behalf of the Public Defender Services Amicus Curiae. When a client expresses anger about something that happened in a case in language that constitutes a threat, the attorney-client privilege should apply for at least two reasons. First, because such expressions of anger relate to the purpose of obtaining legal assistance. And second, because any contrary ruling, including one based on a novel exception to the privilege for criminal threats, would frustrate the purpose of the privilege to promote full and frank communication between attorneys and clients, as well as adherence to the law. Simply put, it's in society's best interest to adopt a rule that encourages clients to confide any threat to harm another person on account of a legal matter to their legal representatives, who are well-positioned to discourage such acts of violence. Mr. Moore's threats to shoot the prosecutor were related to the purpose of obtaining legal assistance in his case because they were related to a goal of the representation, which was avoiding the loss of pretrial liberty. Wigmore has said that related to should be interpreted broadly to leave space for disclosures that attorneys need in order to do their jobs. The purpose of the privilege is that clients will be unhampered in their quest for legal advice. This rationale applies with particular force when there's no question as to the existence of an attorney-client relationship.
Counsel, what if Mr. Moore had said, I need to go talk to my lawyer, walked outside, walked up to Mr. Harvey, said, I don't want to hear a word from you. I'm shooting the prosecutor, and walks away. Do you think that that is significantly related to the purpose of getting legal assistance?
I think there you have bigger questions about whether the significant purpose of the consultation was for the purpose of obtaining legal assistance. And that cuts against a finding of privilege. But I think it's, these things don't necessarily lend themselves to bright line rules. That's a tougher case, much tougher than this one. So my instincts, the needle moves further towards that's not privileged. But that's nothing like the facts you have in this case, where Mr. Moore on the 12th of April said, this is in the context of a discussion. His lawyer's trying to tell him the prosecutor is going to be seeking additional ankle monitoring. He's getting angrier and angrier. Eventually he says, I'm going to shoot her. If she keeps messing with me, I think was the grand jury transcript. And that is, certainly related to his goals of the representation.
What if this is a variant of the question I asked Mr. Day? If what he said to his attorney was, I'm thinking of threatening the prosecutor. In fact, I think that's my best move here. I think we can scare this woman off the prosecution. What's the best way to get her a message where I might threaten her? So not itself a threatening, not itself a threat, seeking legal advice about how best to issue a threat. Do you think that's privileged?
Sure, that is certainly attorney-client privilege. It, in fact, I think is pretty reminiscent of the facts that were at issue in NRA PDS. But
you don't think that fits within the crime fraud exception?
I think the answer to that depends, as you were discussing with Mr. Gray. But the answer depends. As you said, if the attorney nips it in the bud, there's no crime fraud exception.
I agree with that.
There is, I think, some ambiguity in the opinion. So the opinion itself leaves room for fraudulent crimes and fraudulent schemes that are inadvertently advanced by an attorney. right? You don't know that you're helping me, but I'm going to use the information that you're giving me in the course of our communications to further my purpose. So I think that's a not nip it in the bud scenario that is subject to the crime fraud exception. But it doesn't, I don't read the opinion to suggest that anytime there's a completed crime or anytime the scheme comes to fruition, all of the prior communications with counsel.
The way I mean, I take I've had a hard time getting clarity on this question, but I think it might be very important here. If generally speaking, the crime fraud exception is phrased in terms of if the client's purpose is seeking advice to further or advance a crime that fits within the crime fraud exception. Now, in Ray PDS, we certainly said, now, if it's really genuine advice of should I do this or not, and the lawyer nips it in the bud, then you're outside the crime fraud exception and you're back into the privilege. It's not so clear to me. What about the third situation where the lawyer neither advances nor dissuades the client? And I take it your view must be that if the client neither advances or dissuades the client, counsel, I want to figure out how to threaten this prosecutor. How do I get a hold of her? And then the lawyer says, I can't help you there. That would be illegal. Don't do that. He says, I hear your advice, counselor, but I'm going to go track her down myself and do this. Do you have a case in mind? I know I was pointed to the Third Circuit one in Ray grand jury subpoena. But I have to say, it's not generally the sense I get from the cases. The general sense I get from the cases is if the purpose of the communication is to further or advance a crime, it doesn't really matter if the attorney goes along with it. And if you think I'm wrong about that, what would you tell me to read?
I would point your honor to the statement of the holding at the beginning of NRA PDS, which I believe, I'm going to butcher the quotation, but it's the words are actual furtherance. We hold that some actual furtherance is required. And there is debate in the latter part of the opinion about what actual furtherance means. I believe our office, so the Public Defender Service had argued that it means an actual illicit substantial step or something, words along those lines. That position was rejected. The government's position was you don't need anything at all. All you need is the illicit purpose. And that position was rejected. And the majority, the holding was you need actual furtherance. One kind of actual furtherance could be inadvertent actual furtherance, right? Where the attorney doesn't know that he's advancing the scheme, but you do need actual furtherance. And so I don't think this issue is as wide open as your honor has depicted it, but.
Can I ask you then, I mean, we're on Banc, so if it were clear what In Re PDS thought about that, that might be definitive or not, I guess. But I had asked about some language in a Supreme Court opinion that seemed to suggest a much broader view about not so much exactly crime fraud, but just about the duty of confidentiality. So that's this quote from Nix, which also is not binding on us as we're sitting here on Banc. Do you have a response to the language of that quote, which I mean, maybe you think it's overbroad and was not in our context and is distinguishable. So I get those, but do you have other thoughts or just those? And I don't mean to disparage those, but
I'm so sorry, but could you repeat the quotation exactly? Sorry.
Sure. It's this is on page 475 US 174. And it says an attorney's duty of confidentiality, ... does not extend to a client's announced plans to engage in future criminal conduct. That language seems to apply a broader outcome or scope of the crime fraud exception. If my client comes to me and says, I'm thinking, I'm planning to commit this crime, I'd like your help, and I say no, it seems like that would be not confidential. There'd be no duty of confidentiality there, even if there's no furtherance. So I'm just curious, they're kind of tea leaves or different conflicting words in Re PDS. There's also this language in Nix versus Whiteside as we try to figure this question out if we need to resolve this case. I'm interested in your thoughts on the Nix versus Whiteside piece of it.
Sure, Your Honor. I mean, I do think it's important, as appellant's counsel said, to distinguish between confidentiality on the one hand and attorney-client privilege on the other, because the chilling implications of the two different rules are I think, very different. And
So I'm very interested in a more detailed explanation of that point, but just there are two aspects to that, and you've kind of flagged one of them. One of them is just conceptually, if one of the requirements of the privilege is that there be a reasonable belief that it be confidential, then there seems like there's a conceptual connection between them. So I'm interested in your thoughts about that conceptual connection. And then I am interested in the question of whether the kind of, why do you say it's more chilling? I mean, I get the idea that it'll end up being worse for clients if at the end of the day their lawyer is on the stand testifying against them. That's more adverse to them, more uncomfortable. So I get there, I can see some of that. But it seems like there's a lot of chill that would arise from the fact that, normally what you and I say here today will be kept confidential in the sense that I can't tell anyone. But by the way, if I was really laying out all the scenarios, where there's crime fraud, there is if I accuse you of, or if you accuse me of, we get in a fee dispute, or if if you accuse me of professional misconduct, then, those duties are not, that confidentiality duties don't extend that far. If you were adding another one, which would be also, there's this rule 1.6. So if you start saying things that make me fear that I need to say something to somebody because I need to protect somebody's life or, prevent substantial bodily injury. Why is the, marginal chilling depend on whether at the end of the day there's testimony?
because the testimony involves the lawyer. And I think the fact that, so we agree, I think there is a lot of chill or a significant impact on client behavior from the fact of disclosure. And I think that's a key assumption in NRA PDS when they say, we trust that attorneys, the threat of disclosure will keep clients from acting on threats. Or sorry, not acting on threats, but acting on illegal courses of conduct. We trust that the attorney's duty to withdraw and ability to further disclose is something that's going to help rein in dangerous behaviors that we want attorneys to be able to discourage their clients from engaging in. I think that's point one.
Isn't that why the language in NICS just cannot be read literally?
I think that's
Right?
correct,
I
Your
mean,
Honor.
because if an announced plan to engage in future conduct just suddenly has no confidentiality, has no privilege, right? There's no room to have the conversation to advise the client, don't do this, which is what we said in NRA PDS was essential to the attorney-client relationship and is the raison d'etre for the privilege, right? Like, so you can't read that language literally. And all of this conversation about how far the privilege goes or when it stops has to be read with an understanding of whether the privilege is being used to promote the attorney-client relationship or misused, right? So if you're using your lawyer to perpetrate a crime, you are misusing the attorney-client relationship. But outside of that, you're using the attorney-client relationship, and maybe the attorney is failing in their job, but failing is different than misuse.
I think that's correct, Your Honor. And, I'm partial to this court, but my sense is that given any tension between, assuming a tension between NICS and NRA PDS, I think this court's reasoning is very persuasive.
It might be persuasive in a case where the person is ultimately dissuaded from committing a crime, because then it really seems like they're seeking legal advice. NRA PDS involved false witness statements and trying to get the lawyer to engage in the illegality. Whereas, so I could see why you would say, well, when they're really seeking advice and they could be dissuaded and they have been dissuaded, you want to cover that. That makes a lot of sense. It makes much less sense to me if you imagine a client who says, counselor, I'm not really interested in your advice on this one. Here's how it's going down. This is what I'm going to do. And I'm going to go and, harm one of the witnesses, intimidate one of the witnesses. Counselor doesn't do anything to advance that, but also is neither dissuades the client, nor was ever sort of consulted with the possibility of dissuading the client. And then it makes much less sense to me why we would cover that by the attorney-client privilege. I mean, what's the sense behind that?
I mean, the sense,
I'm not open to persuasion, counselor. This is what I'm going to do.
we're always, sorry.
I mean, that's the question. In re PDS, I take it, I see the language you're pointing me to. But it is a case where the client was really seeking the lawyer's participation in a crime, and the lawyer saying no puts an end to it. So it makes a lot of sense to say, well, if the lawyers can put an end to it and they do, no harm, no foul. If the lawyer's in no position to put an end to it, it doesn't make as much sense to me.
I think when the lawyer is not in a position to judge as they sit hearing the advice, whether they can do something about it or not. In re PDS sets an optimal set of incentives, both for the lawyer and the client, for the client to come to the lawyer and say, I'm thinking about doing this, or I'm so mad I want to do this, or I need your help. Can you help me do this? All three of those scenarios in re PDS sets optimal scenarios for the client, optimal sets of incentives for the client to say, I want to tell my lawyer about this because it's about my case. And he's the person who said he's going to fight for me and also knows the system much better than I do. It sets a good set of incentives for the attorneys as well, because they then, if you don't want to see this in court, go to the wall, do everything you can to talk the client out of it. As the case cites, it's not just us being good-natured people and caring about public safety. It's our obligation as attorneys. It's in the ethical rules. And I think the court is well justified in reposing confidence in those ethical obligations. But I think the shorter answer to your question, now that I've spoken for much too long, is that we care about the client's ex ante. We don't just care about the one that's sitting in front of us. We care about everyone that we might meet and making sure they have a good set of incentives to trust us, confide their violent urges in us, so that we can talk them out of it.
Mr. Collins, I asked Mr. Day to tell me the difference between Mr. Moore actually shooting the prosecutor in the hallway versus what he said here. And the answer was, well, a threat is a communication in addition to being a criminal act. And we all agree that the communication has to be for the purpose of seeking legal advice, right? Or related to the purpose of seeking legal advice. So what part of the communicative aspect of a threat is seeking legal advice or related to the purpose of seeking legal advice, as opposed to the purpose of perpetrating the threat itself?
So I think there are two answers to your Honor's question. In this case in particular, you have a situation where someone is at the end of his rope and saying, I want to kill this person. I want to kill my adversary in litigation because they filed a motion against me. Directing those statements to the attorney is a plea for intervention. It is, do something about this. You don't understand how much my job means to me. You don't understand they're trying to persecute me. If this person keeps messing with me,
So it wasn't a threat. It was.
I don't think those two things are inconsistent. I think that reading can be reconciled with the jury's verdict, although I leave any interpretation I defer to counsel on appellant's counsel for those fact-specific issues. But I think it can be reconciled with the verdict, which only required knowledge that the statement would be that someone. I think the language of the jury instruction said someone would view the statement, knew that someone would view the statement as a threat. And you can be, bubbling over with anger, and it doesn't matter who's, sort of by definition, when you're so mad that you're going to say something like that, you sort of there's a disregard for the knowledge that someone may hear it as a crime. I think
You're not arguing for like a case-specific inquiry into. So let's say the next case comes down the road and client A is angry about what's happening in court and goes out and talks to the defense attorney and says, I'm really angry, I'm going to kill that person. Are you saying that there's a case-specific inquiry into whether part of the subjective thinking of the defendant was an implicit plea for help rather than just an outright statement of a plan with, I don't care what you think. I'm not interested in your opinion. So, or are you saying, are you suggesting something more categorical, or is it really, we're gonna have to zero in on, or trial judges primarily will have to zero in on like a very case specific inquiry into what you might infer or what a defendant might have to testify at a hearing would have been the subjective, implicit or explicit purposes of a threatening statement?
No, I am advocating, we are advocating a more categorical rule. And I think anytime you have venting, sort of setting aside all of that analysis I just rattled off, anytime you have a statement that's motivated by this degree of anger, any kind of emotional outburst, it's putting the client in a position where they can hear our advice. And so it is advancing the representation in a very material and tangible way.
Well, but counsel here, the statements made out of anger and frustration, as you said initially, the lawyer did counsel the client, stop, don't say that anymore. If you say that, I'm going to have to go and tell the judge. And the client continued and persisted in saying, again, I'm going to shoot or kill. I don't remember the exact words. Uttered a threat under our laws of complete crime. So I'm trying to make sure I'm understanding whether you're saying these statements are statements, the threat I'm talking about, whether it's a conduct and an action, whether it was part of the relationship and always will be, no matter how specific the threat might become. I guess this is a follow-up to the question from Judge Schenker about what aspect of the threat that was uttered was seeking legal advice here. It seemed to be in defiance of the advice. If we look at the second threat, defiance, I could arguably agree with everything you said up until the point where the lawyer said, look, you have to stop saying that. You can't do that. Or I'm going to have to talk to the judge, or whatever the exact words were. So once you get beyond the point where, if arguably you believe the client was seeking advice and help and venting, after the advice that he was seeking in your assessment, he's told, no, don't do that anymore. Stop. This is not right, whatever the words were from the lawyer. And then he says it again. And then we also have, if I'm recalling the record right, we also had video in that corridor that, while it didn't capture the words of the threat that was uttered, only the attorney heard the words, we do have the actions seen of making the symbol of the gun as part of the threatening language that was uttered. Does that make any difference? I know counsel for appellant argued that there's a difference between conduct and communications. Here, this threat was verbally communicated, but there was also some conduct, arguably, in evidence that showed that it was more than just a verbal communication here.
If I can work backwards, Your Honor, I think.
Yeah, that was a lot rolled into that question.
I'll try. And my memory is not good.
I think it's pretty good.
But the videotape, there's no privilege that attaches to that. Moreover,
I'm not talking about the videotape. I'm talking about the action
counsel could certainly be
by
called to
the defendant of
Sure,
making
sure.
the gun symbol.
the action, the conduct, the deed, as it were, is.
Can I just zero in on that? Because that seems, I mean, I would assume you would say that communicative actions could be subject to privilege.
That is true, Your Honor.
And isn't the making of in the context, wasn't that a communicative action? Why is it different from saying, I mean, it's in the context of it, it's saying, I'm going to shoot, it has a communicative component. So I'm a little unsure about the line you're drawing between conduct and communication, because communicative conduct straddles it.
That is, and I want to be clear, this isn't a line that we are drawing. This is a line that's the authorities and treatises have drawn since time immemorial. So this is, this is Wigmore, but there are statements that have a communicative component, or sorry, a conduct that has a communicative component can be subject to the attorney-client privilege. If I am seeking information and, you nod your head in affirmance, that nod is as privileged as it would, as if you had said yes.
Right, so just to be concrete here, imagine that imagine there's no video, and imagine that the testimony at issue was not from the lawyer. It's established from people other than the defense attorney that there was this dispute about whether Mr. Moore would be his conditions of release would be changed unfavorably to him. Mr. Moore was visibly angry. He comes out into the hallway and he interacts with the defense attorney. And the defense attorney says during that interaction, he took his finger and he, turned his head and he looked over to the prosecutor and he went boom, boom. Would you say that is covered by the privilege, or would you say it's not covered by the privilege?
Well, I think the answer to that depends on something other than the related to tests and the significant purpose test. I think those gestures are as related to and is infused with the same significant purpose as if he had said, I'm going to kill that person. Because, on account of
I agree with
whatever.
that. I completely agree with that.
Yeah.
And it's a fair response that that's a murky line, and nonetheless, it's one that exists in the law in lots of settings, including this one going back. So that's very fair. I'm just trying to figure out whether the logic of the position being taken here is that really what also ought to have been excluded, leave aside the video, but any testimony about gestures like
Testimony about the,
yeah.
yes, the testimony about the gesture should be, and I misspoke. Our position is that that testimony should also have been excluded.
Can I take you back to my question? If you remember where we were, I was trying to tease out a little bit this related to or a part of the advice seeking piece. And what I understood you to say is that it's important, and I agree, that clients should be able to vent, they should be able to seek advice and seek a rational, calming, thoughtful advice from their attorneys, and you want to keep those lines of communication open, which seems to be what happened here in the early part of when some of these comments were uttered. And counsel then said, okay, enough. You can't do that anymore. And then the lawyer continues the client continues to utter the threats, which are then accompanied by the physical actions. Why isn't the part after the client has been counseled, warned, now, or why do you still consider that second threat to be a part of the relationship or the attorney-client relationship and not either outside of it and therefore no longer subject to the privilege?
For one, I think the record shows a long lapse in time between those two conversations, the one on April the 12th and the one on June 29th. And I think the court should definitely take that into account. But again, we're going to defer to Mr. Moore's attorney with respect to that kind of parsing of the record. In terms of how such a statement could relate to the purpose of obtaining legal advice, I think even assuming arguendo, he knew that his attorney didn't want him to say those kinds of things. When you're expressing an emotion about an aspect of the case, the clients determine the goals of the representation. He wants to stay out of pretrial confinement or any kind of pretrial encumbrance on his.
He wasn't asking at the time of the second or the June threat, he wasn't asking his attorney, how do I stay out of pretrial release? He said, I want to shoot, I want to kill the prosecutor.
Even
after having had earlier conversations with his lawyer, where the lawyer said, don't do that.
Sure, Your Honor. And I think we are treading into dangerous territory when we tell people how they can and can't respond to the circumstances of their case. And so, to a certain degree, keeping those lines of communication requires according a wide berth for abusive language, impolite language,
Criminal
and criminal threatening language. Yes. in order to make sure people have avenues to express themselves about what's happening to them. Mr. Moore was facing a very stressful situation, loss of liberty. He could barely contain himself when he was in court. And then the case, there's an adjournment and he goes outside and he wants to talk to his attorney. And he chose his words poorly, but there is seemingly no doubt that he was beginning trying to continue a conversation that was happening at council table rather than saying, I'm done with legal advice for today. Let me go kill the prosecutor.
That kind of sounds like what he said here. He wanted to go kill the prosecutor. I mean, I like I said, I get everything you're
Well-
saying about the need for the wide berth and viewing the privilege broadly and maintaining a sacrosanct bond between the lawyer and the client. And I guess my questions toward you and appellant's counsel have been aimed at sort of testing the limits of that.
Sure, Your Honor.
And I guess what I hear you saying is that there are no limits.
No, we don't think that's true. At least under, we understand the court is en banc and could, in theory, hold today or holds when this opinion comes out. There are no limits. But what I'm advocating is that the traditional test for the privilege presumes between it in the context of a well-established attorney-client relationship and a consultation whose purpose is to impart legal advice, to relay a legal consultation. After those 2 points, a presumption is triggered. Even if one is not, I want to be clear about this. What Wigmore says is you need a knowing departure from the purpose of obtaining legal assistance or advice.
What if the threat had been, I'm gonna shoot the judge when I go in there? You don't think that constitutes, when you say the willing departure, are you talking about on the part of the client or on the part of the lawyer?
On the client's part.
And so you think that the client wouldn't know that certain kinds of conduct is a departure from what he could reasonably expect confidentiality out of his lawyer?
When you have an emotional outburst like the one at issue here, I think it lends itself very poorly to that kind of retrospective motives analysis. And even though the jury could conclude on some level that he knew, a person who heard that would conceive of it as a threat. The whole point of venting is that the emotions are so intense that you need to do something. And so he's saying that, and that's what he said. But I think you can't say based on that he had abandoned the purpose of obtaining legal assistance
Well,
in this
counsel,
case.
would it be enough for you in drawing limits if, even with a completed threat, a attorney had an opportunity in the moment, ignoring 3 months before, in the moment, to provide counsel, and that the client persisted beyond that, and then it became problematic? Would that be enough that there was an opportunity to counsel there?
If there had been an opportunity to counsel in the moment, and
Yes,
he,
if there was a completed threat, if the client said, I'm going to go bust a cap, as was done here, and the attorney had the opportunity right after to say something before going to report and did, and the client persisted, is that enough then to bring it outside of would that be sufficient opportunity for the attorney to counsel to provide that opportunity to rectify things from INRI PDS, and then confidentiality no longer applies if they persist? Would that be satisfactory in your view?
I think there are circumstances where through words and deeds, the client can make very clear they don't want, they're done with the law, and they want to take a different tack with respect to their problem. And I think what Wigmore counsels and what all these treatises and authorities counsel is that the court should construe that type of determination very narrowly. You should not lightly conclude that somebody said, I'm done with you as my lawyer and with your advice. You should require a pretty strong showing on the record that's what happened in the case. And so for all of those reasons, I think this case is very far removed from that. If there are no more questions, I would like to reserve a moment of rebuttal.
We know we took you over your time with our questions, but we'll reserve your time for rebuttal. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court. My name is Chris Ellen Kolb. I represent the United States in this matter. With me at council table is Mr. Graham Phillips of the Office of the Attorney General. We have ceded 10 minutes of our time to OAG. Your Honor, this court should not adopt the rule that's been proposed in the division's opinion here. It is overly broad. It's not within the confines of our typical Wigmore test, and it does not promote the administration of justice and the observance of law. A wide berth and the importance in order to assume and protect the importance of the attorney-client privilege does not license the client to utter criminal threats in violation of the law.
So
It is really that
counsel, the government's position, am I correct, is that we should stick to the Jones formulation of whether a purpose is significantly that of obtaining legal assistance?
Yes, Your Honor.
That's correct. Okay.
That's correct.
So if I could just jump into hypotheticals, I'm sure others on the bench have more for you. But this one will sound familiar because it was a hypothetical that was posed at the division argument, right? So if Mr. Moore had come out into the hallway and said to Mr. Harvey, the prosecutor is out to get me, she's screwing up my life, and I think things would be so much better for me if I shot her. So I'm thinking about shooting her. What do you advise, right? Does the government think that that communication with counsel, the question and the response, would be covered by the attorney-client
I
privilege?
think under this court's conception of the attorney-client privilege, if the attorney is asking that question, which has a threat baked into it for sure, a potential threat, I should say, baked into it, that's a request for legal advice. And one of the significant purposes is to obtain legal assistance. But let me note, Judge, with respect to the Jones opinion, the Jones opinion cites the restatement and relies on the restatement. And the restatement at 72C says, in deciding whether or not a client is making a communication for the purpose of legal representation, one of the factors to consider is the nature of the communication itself. And
Right.
that's something
But the nature of this communication is, as you say, it's got a threat baked in. So now I've got a follow-up hypothetical. You have the hypothetical with the savvy client who knows to ask for advice. What about the client who's just done a lot of therapy and is very in touch with their feelings and says, I am so mad at the prosecutor for requesting GPS monitoring. I am enraged and I feel like shooting her. That's how mad I am. That's how I feel. And then the counsel responds, is that communication covered by the privilege?
if the attorney believes that that's a true threat, then it is not covered by the privilege. It's not seeking legal advice. It is a
so
statement
you
of an
think-
intent.
You,
And it's a completed threat.
sorry, do you think that it always has to be posed as a question to get legal advice?
Not
Right,
necessarily,
I
although,
walk out of the courtroom and I go up to my lawyer and I say, I am terrified of going to prison. Is that, it could be seen as a statement of admission of guilt, right? Is that not covered by the privilege? Because I've been asked the lawyer to reassure me. I've just
That's the
told the
connection.
lawyer about how I feel.
Judge, that is something that is, and I think we wouldn't fight, that's reasonably in connection with the representation.
Well,
And
why
it's-
isn't my hypothetical, I am so angry at the prosecutor for requesting GPS monitoring. I feel like I could shoot her. Why isn't that connected significantly.
It's
to the
connected
purpose
and it's a
of the
harder, look,
representation.
that's a harder hypothetical. And I think in most cases, as I think we've all discussed earlier today, an attorney would, in the right exercise of that attorney's judgment, talk to the client and try to explain to the client, that's not a good idea. And as in this case, that's kind of what Mr. Harvey tried to do. And instead, the
Right,
client
because
doubles
Mr.
down.
Harvey recognized that what Mr. Moore did, right? He wasn't savvy enough to ask a question. He wasn't emotionally regulated enough to just talk about his feelings. He just came out into the hallway and sort of vomited rage, right? And said, I'm gonna shoot the prosecutor, pejorative, violent intention, right? He uttered threats.
And, but Mr.
But I
Harvey,
guess my question is, how, those statements all seem like on a continuum to me. And if we're going to distinguish between them, it seems like we're doing so on the basis of syntax or on the basis of distaste for the precise language. And if the whole point of the attorney-client privilege is to promote the use of counsel, wouldn't you think that the person in scenario three, Mr. Moore's situation, is the one who is most in need of the use of counsel, right? He is the one who needs counsel. He is the one who needs talking down. He's the one who got talking down the first time and it worked
well,
for a time.
for a brief period of time. But the point though is Mr. Moore was counseled and he doubled down on both occasions. On the first occasion, on April 12th, Mr. Harvey said after he uttered the first threat, Mr. Harvey said, what are you talking about? I'm thinking you serious. And the defendant said twice that he would shoot that bee. And that's at page 89 of the transcript. Then we get to later after Mr. Harvey goes in to talk to the judge and he comes out and he says, look, I might withdraw. And Mr. Moore then says, well, I was just bullshitting. And Harvey says, well, you can't say that again. Now we go to June 29th. The defendant then threatens to bust a cap in this bee. And Harvey asked again, what are you doing? And that's when he proceeds to do this and makes pretty clear, that's what I'm doing.
So
That's a
Ms.
threat.
Cole, earlier you said if the attorney reasonably or correctly, I can't remember what you said, perceives it as a threat, that's kind of the line. And I'm curious about that because when we get to the actual privilege stage, the evidentiary stage, presumably we will have pretrial litigation on the admissibility of this evidence. I'm putting aside the grand jury question, which is tougher. I'm not sure anyone's really argued about it in this case, but at the trial stage, I'm a little worried about it, the completed crime aspect or the threat aspect of this turning on the attorney's perception. You could have a highly sensitive attorney, you could have a very permissive attorney on these things, but do we or do we not have the backstop of the trial court determining whether something meets the definition of well, not the ultimate legal conclusion or factual jury conclusion, whether it's a threat, but whether it at least meets the definition of a threat for purposes of overriding the privilege for admissibility purposes, or do we not? I mean.
Well, I
see
think
what
there
you-
are two layers of protection here. I think the first layer of protection is the ethical rule 1.6.
Right.
Okay. And so the attorney there can basically reveal a secret or a confidence if it's reasonably necessary and that the criminal act that's involved reasonably believes it's likely to result in death or substantial bodily harm. So that's one threshold. The second threshold then would be the judge would then determine, as occurred here with Judge Isco, whether or not the privilege should apply or whether the evidence is admissible. And here, this evidence and the statements that were made by Mr. Moore were not seeking legal advice of any kind.
So
Your protection, you identified two protections, but if I understand your legal theory, you don't think both are necessary. Let's imagine that what Mr. Moore had said instead of threatening to kill someone was silly hypothetical, but that he said, I'm going to go in, I'm really mad at this prosecutor. I'm furious. I'm going to go in, or I'm going to go key her car. So be disruptive. That's a crime to say that. it certainly wouldn't be covered and disclosure wouldn't be authorized as ethical under the ethical rule. So that protection would not be applicable.
Correct.
But if I understand your position, also not privileged.
I think it's not privileged, but in reality, that hypothetical likely would not present itself because the attorney under the ethical rules wouldn't make that disclosure.
Well,
Now,
who's to say? I mean,
Well-
in this case, right, Mr. Harvey is never makes a 1.6C1 disclosure. He goes into the court and says, you have to order me to disclose this. So he makes a 1.6E disclosure. The court says, okay, now I'm going to order you to say it. And then he says it. So what if Mr. Harvey is so offended that the defendant is going to key the prosecutor's car that he goes into court and says, you're not going to believe this, but I can't tell you unless you order me to tell you. And then the court orders him to tell him that the client just said, I'm going to key the car. And so that, I mean, I think we have to explore all the possibilities. That is not privileged.
that would not be privileged because it's not a statement that's made for the significant purpose of obtaining legal advice. But again, I
am still struggling with why that is so, right? I mean, why can't we have two thoughts in our head? That one, the person is uttering a threat to commit a crime, and two, they are communicating their deep, unregulated, irrational, unproductive anger at the situation that they are in their case. And the lawyer can certainly respond to and help redirect, be the sounding board, be the anger translator for the latter, right? Why don't we want that to happen?
Your Honor, ideally we do, but here's the problem, is that there is a line, and I think this is the line that the dissenting opinion discussed here in this case. There's a line between venting and there's a line between criminal threats. And we don't
Let's
put,
stick with the keying the car. Right, let's stick with the keying, because I feel like so much of the conversation with threats touches on safety concerns. And safety concerns are addressed arguably by 1.6C1. But let's take the hypothetical where there is no safety concern, there's a property damage concern. Why then, if we've got a criminal act coupled with anger about the case, why does the privilege lift in that instance? Why don't we want the lawyer to address that anger, deal with that anger within the confines of the attorney-client relationship?
well, again, Your Honor, I'm going back to Rule 1.6 because Rule 1.6, I think, which gives the attorney some discretion as to when to make these disclosures, number one. Number two, the attorney under the ethical rules would not make the disclosure.
I know,
Right?
I understand, but there are other instances where the disclosure might be made. And maybe the lawyer is just disregarding the ethical rules. Maybe the lawyers, I mean, who knows? But under my hypothetical, confidentiality, that, the information has been disclosed, and I'm trying to figure out why the attorney-client privilege should not apply in that scenario of Judge McLeese's hypothetical.
Well, with respect to the keying of the car, it is not, the significant purpose of that statement is not to obtain legal advice. And that is the question for the privilege.
Can I just pause you there? So, I mean, I think we talked about some earlier examples where you would admit it's not really a statement by statement analysis, whether or not somebody's seeking legal advice. So, if I run into my attorney's office and say, we got to keep this quick. I parked in front of a fire hydrant. Then for some reason, he's very offended by that and he wants to report that I've illegally parked. I think that would probably be covered by the attorney-client privilege, even though I've asked for no particular advice. I think you would agree with that?
I don't see how that's related to obtaining legal advice.
Oh, really? We have to keep this quick? I mean, it puts
That's just a random comment, though. I guess.
Random comments happen in attorney-client conversations all the time. And if what we're doing is a statement by statement analysis of what goes on in a communication between a defendant and an attorney, I mean, good Lord, 80% of that conversation isn't going to be privileged. And that seems like a way too sweeping of a rule. I don't think you want to defend that line, do you?
Oh, Your Honor, no, not necessarily. But the point is, It is the burden of the party who's seeking to claim the privilege to show that the privilege applies, okay? And so in that situation, if the party could show, I was seeking legal advice, and in the course of seeking my legal advice, I happen to say, I need to make it quick because I'm,
But you think that's on a statement by statement basis rather than, the communicate. When I went into my attorney's office, all we were talking about was the case. And, one of the witnesses and I, got in a fight earlier that year. I thought that might have been relevant to the case. And so I mentioned it. But if the attorney says, no, actually, that wasn't relevant to your case, it didn't really matter. He should report me for that.
well,
past offense?
that's a past crime, number one. And that's in a different.
No, I guess I'm trying to posit, let's say it's not even a witness. I just,
Okay.
this is not my first brush with the criminal justice system, counselor. I previously, I've been wanted on another crime. They haven't found me yet. Has nothing to do with this particular one, but just to let you know, I've had some brushes with the law before. That really doesn't have anything to do with the representation. But I mean, I really don't think the line you want to police is on a statement by statement basis. Something needs to be, express requests for legal advice.
Well, it doesn't always have to be in the form of a question, but it needs to have a significant purpose of getting legal advice. And that's the test that this court has applied.
So here's another hypothetical for you. Mr. Moore comes out of the courtroom and says to Mr. Harvey, I'm going to kill the prosecutor. That's a threat. And then turns to Mr. Harvey, or he's already talking to Mr. Harvey, but he tells Mr. Harvey, I'm going to kill the prosecutor, and then asks, should I kill the prosecutor? And Mr. Harvey says, it's a terrible idea. It will not help you. That's, would be horrible to do, to take a life. And then Mr. Moore says, you're right. I shouldn't do that. Never mind.
And I think that
Is the whole of that conversation privileged, or is it just the should I kill the prosecutor and the response? Is the threat that precedes, because it's a threat?
Right. There has to be some context, and I'm not disagreeing with your honors, but that's very similar to a situation like in re PDS. And so in re PDS would suggest that conversation, when the attorney talks the client out of the bad conduct, that's achieved the purposes of the representation. But in re PDS, and I think this is very important because there was a lot of discussion about it with my colleagues on the other side. In re PDS first of all, it doesn't deal with threats per se. It deals with a different situation about witnesses and witness testimony that may have been unfairly coerced. But in re PDS, the court says in the opinion, I'm quoting from 909, that the privilege is forfeited ab initio, where the communication itself advances a crime or fraud. In other words, and it also says it looks at the communication itself. That we think is this kind of case.
I want to take you back to this case. I know we have a lot of different scenarios and hypotheticals trying to help us test the limits and where the line is drawn. And under the facts of this case, I'm trying to clarify whether you're saying that the threat uttered in June, I'll focus on that one for a second, was outside of the attorney-client relationship and therefore not privileged, and therefore it would not be a violation of the attorney-client relationship. So not unethical, not subject to confidentiality under 1.6, and therefore would not be a violation to go a step further and testify against the client. So there's two levels, and you started to talk about that a moment ago, and I'm not sure if you finished your response. And then my last point is, are you saying that the threats should be carved out as a new exception? Are you saying it's already something that we have to consider under our existing rule? Or are you saying we need to go further than our existing rule and carve out a separate precedent? And I'm hoping to get a chance.
No,
to answer.
Your Honor, we don't think the court needs to carve out some new exception. We think that the application of the extant rules in this court would say that a criminal threat uttered to an attorney is not covered by the privilege. It is not a request for legal advice, but it's not covered for the secondary reason,
How-
is that it doesn't,
I just want to hear her finish this, if you don't mind.
the second reason it's not covered, Your Honor, is that protecting that kind of communication is not consistent with what the attorney-client privilege is for, which is to advance the administration of justice and the observance of law. That doesn't happen when the attorney-client privilege basically allows a defendant special privilege to violate the law. That's not what the attorney-client privilege stands for in our view. And that's why this evidence was properly admitted in this case.
So just to try to be absolutely clear, under that purpose and talking about the prophylactic measures from Emory PDS, and you've talked about attorneys being able to convince people outside of it. Just to be absolutely clear, it's your position that in the case of a threat uttered to an attorney, there is no prophylactic measure. It's done right there. The attorney doesn't need an opportunity to deal with it, to try to counsel on it. It is automatically out from, ab initio.
Well, I think In re PDS would support that view, but I think in reality, I think in many cases, the attorney would take that as an opportunity for counseling and to try to, and some of the treatises talk about this, to remonstrate with the client and basically have the client say, no, I didn't really mean that. I'm sorry, I misspoke, or I know I'm getting too mad. I'm not suggesting it's never possible, but I think the square reading of In re PDS is that type of communication in and of itself, if it's a true threat. And I think I believe one of the judges asked earlier, well, what should an attorney do in this situation? Well, one of the things the attorney can do by interacting with the client is to ascertain, is this a true threat? Saying, like Mr. Harvey did, are you serious? Really? You shouldn't say those things. That's, I think, fair game and part and parcel of what the attorney should do in deciding, is this a true threat?
Counsel, I'm just not quite sure I get your categorical view that anything that is a completed threat can't relate to the getting legal advice. And so here's another hypothetical, which is imagine that an angry defendant comes out and says to the lawyer, I have a question for you in your capacity as my lawyer. I'm going to kill the prosecutor, and I'd like to know, whether what the penalty would be if I did that. That's a completed threat. I think I'm going to kill the person. That's a completed threat. How is that not related to the purpose of the representation? I mean, there might be exceptions that mean it shouldn't be protected. I get that, but how is that not related to the purpose in any normal sense of?
The purpose of the representation is, you're representing me in some other criminal case, and I'm mad at how it's going. My anger about the prosecutor and what I'm going to do as a result of that is not as directly related as it would be in other circumstances, first of all. But even if you take a broad view and say, well, it has some general relationship to the fact that we're here in court and we're dealing with this prosecutor, okay, then we get to the second, then it might be deemed under a very broad view related. But that's where we go to the second piece of our test. The second piece of our test is this the type of statement that the attorney-client privilege is really meant to protect? And we say no. The attorney-client privilege, and there's lots of cases that say it should be narrowly construed in order to effectuate its purposes. The purposes being fair, full communication with the lawyer for sure, but also the observance of the law. And you can have a full communication with your lawyer without privileging someone to violate the law of criminal
And you
offense.
say that balance of interest is the same no matter how trivial the crime is. So again, if in my hypothetical it was, I'm really, I'm angry, I'm the defendant, I walk out of a courtroom, I say to my lawyer, I'm really angry at what the prosecutor is doing in there. I'd like your advice about something. I'm going to go key the prosecutor's car. And I'd like to know what my penalty is going to be. I'm sure it's worth it, but I'd just like to know. You would say the interests are that, the social interest in all of that is that has to be treated as unprotected.
It's not protected, but in reality, as I said earlier, under 1.6, if the only person who heard that statement is the lawyer, under 1.6, the lawyer is not going to make that disclosure because it doesn't meet the very high threshold under 1.6.
And aligned with Judge McLeese's question about the balance, right? No matter how trivial the crime, no matter how dire the straits of the speaker. So I am a domestic violence victim, and I am talking to my divorce attorney about custody of our children. And she is explaining to me that it is very possible that my abuser will get joint custody of our children, and he has abused me and my children. And I say in desperation, if he gets the children, I will kill him, right? I have no choice. The children cannot survive with him. I would rather go to prison than let him have the children. I've uttered a threat. I am unprotected by that. There's no opportunity at that point for counsel to talk to me and say, we are going to put forward the evidence of your abuse, the evidence of your children's abuse. We are going to explain to the court that he is not safe, that he is not worthy of it. It's over, right? Because I have uttered a threat out of my desperation about protecting my children.
If the lawyer believes that's a true threat, and again, we
It's a
do.
true threat
Okay.
in my hypothetical.
that's not-
It's
and then it-
absolutely a true threat.
Absolutely, then it is not privileged. And the result would be, just like in this case, it's disclosed, we go to trial, and you make the arguments to the
And I
jury.
lose my children because now I've demonstrated myself to be a criminal threatening.
Well,
person.
you would make a pretty compelling duress and other types of arguments to a jury. And the jury would consider whether or not, under the totality of the circumstances, it was a criminal threat or not. Now, Mr. Moore, notice, made those same arguments here. He made all of the arguments that are premised in some of the court's questions today, namely that he was just angry, that this is part of what people do with their attorneys. You have to expect this. The jury rejected that. And so he had the opportunity to basically vindicate the interest and the concerns that the court has raised. And that happened in this case.
You know, did Judge Isco really analyze that question, though? I mean, Judge Isco certainly said this was not a request for legal advice. Did not really analyze whether or not it was a true threat in finding the privilege waived, did he?
Your Honor, he said it has absolutely nothing to do with legal representation and legal advice because it was just a statement of anger. And he didn't go through the standards of what is a true threat and talk about whether it was a crime, which kind of makes sense because it was a pretrial motion in a threats case. He's not going to prejudge that the evidence is.
Well, I mean, if you want
threat.
to advance principle that threats fall outside the privilege, which I'm not totally sure if you are advancing that principle, but maybe that is a categorical rule you're advancing. It seems potentially problematic that Judge Isco's ruling did not indicate that this was a true threat. He didn't make a finding like that. He said he relied on what you referred to as step one of your analysis. This didn't really relate to legal advice. A question that I tend to think we ought to view at a pretty broad level of generality in terms of the conversation that's happening. Now, on the secondary question of was it a threat, we don't have a ruling on that. And so I wonder how much you can rely, or do you think
Well,
that's...
I could rely on the jury's verdict. And he was charged, remember too, there was an indictment and Mr. Moore, at the time Judge Isco had the case, there was a grand jury indictment, at least of a probable cause showing at that point, that there had been a threat and that there had been obstruction of justice.
Can we talk for a second about the grand jury? Because Mr. Harvey gets to go in front of the grand jury with no process for Mr. Moore, which I find kind of shocking, but no one's talking about, right? I mean, one would think in the ordinary course, right? Certainly in the civil sphere, when lawyers get, called before the grand jury, they resist the grand jury subpoena and there is litigation before everything is outed, right? And before Mr. Harvey gets to tell his version of the events. And that didn't happen here.
Well, Your Honor,
right?
first,
And
the record
it's
doesn't
kind of
really-
surprising that Mr. Moore, the record doesn't say, right?
record doesn't say
And so
exactly
we
what
have
happened.
no idea what happened, but it is pretty shocking that there was no one there to speak, that Mr. Harvey didn't resist the subpoena and that there was no one there to litigate whether the privilege could be breached before it was breached, right? And to talk about all these issues about, well, what was actually going on with the 1.6 disclosure that he never made under C1. He tried to argue 1.16. He ultimately got the judge to order him under 1.6E, right? None of that is ever litigated. And so he is able to breach the privilege And then when Judge Isco is looking at whether or not this testimony, the cat's already out of the bag, can then come in at trial, he has the benefit of the grand jury transcript.
Well, I three things, Judge, I want to point out in response to that concern. Number one, we don't have a record exactly of what happened in the grand jury, and I really can't, even if I did know, which I don't, I couldn't talk about that in open court anyway under Rule 6E. Number two, in order for a prosecutor to subpoena an attorney, there is an internal procedure that we have to follow under the U.S. Attorney's Manual, and that's at 9-13-401. And that you have to basically show that if you're subpoenaing an attorney to get approval from, I believe it's the Deputy Attorney General of the Criminal Division, that you're not seeking privileged information. That showing has to be made before any AUSA can try to subpoena a lawyer. And third, in terms of whether or not Mr. Moore's rights were adequately protected, yes, we did have a grand jury transcript, but it was fully litigated in front of Judge Isco. He could make
After
those
the
arguments.
fact, and I guess I'm just
Well,
sort of
he could
curious.
certainly make those
Is there
arguments.
any process? I understand that the government has its own process to assure that it's not seeking privileged information, but is there any process to ensure that the person whose lawyer is being called actually has representation in that matter, or does the government?
Well, the attorney, I mean, again, we're speaking
consider that
hypothetically
person on
because
their own?
I don't know what happened in this case.
No, I'm just asking procedurally.
As a procedural matter, I think in many cases that I've seen, the attorney who is subpoenaed would assert the privilege either on behalf of the client or the attorney, him or herself.
Exactly. But
Right.
if the attorney, as Mr. Harvey did here, does not assert the privilege.
Well,
What then?
again, I don't know if there was what negotiations and any other thing that might have happened. We don't know that in this record. We don't know what happened in the grand jury. And so
I'll make it hypothetical. If
Okay.
an attorney does not assert the privilege, is there any procedure for a defendant like Mr. Moore who would like his privilege rights to be litigated before the privilege is breached?
Well, if Mr. Moore had knowledge that his attorney was going to the grand jury, he could certainly file a request to quash the subpoena with the chief judge. That I've seen that happen because he would have standing if he claims it's his
Is there a
privilege.
process to inform Mr. Moore of?
That I don't know if it's a formalized process, but one would assume, or I think it would be fair to say that, many of the attorneys would probably tell the client. I don't know that though. I don't know. But I certainly think there is a way for someone in Mr. Moore's hypothetical position to protect his interest. And he could move or could have moved hypothetically to quash the subpoena. And the chief judge deals with those requests quite frequently.
Just to pivot a little bit, and this might go back to one of Judge McLeese's questions about what the government's view is when a communication is both a completed crime and clearly a request for legal advice. I'll throw out a different hypothetical. Let's say somebody is about to go to trial under the revenge porn statute, distributing a sexually explicit photo without the other person's consent. Then before trial, the attorney says, gee, I'd really like to know what image we're talking about. I need to judge whether or not it's sexually explicit, and the defendant shows him the photo. That's a communication, at least arguably a violation of the statute itself, because you've shown the photo, distributed it to somebody, but clearly in pursuit of legal advice.
Correct.
When there is that, it is both a completed crime in itself and just posit it is for seeking legal advice, as I think the hypothetical, and I think Judge McLeese's hypothetical presumed one as well. What's privileged or not?
Well, Judge, I guess I'm hoping I'm answering your question, but I'm not sure that it would be a crime to share with your attorney that type of photograph, pornography, say child porn or revenge porn, whatever you want to say. I can't imagine that would be a showing that would be done with the necessary mens rea under the law to constitute.
I thought when I looked at the statute, well, let's just assume the statute says the only mens rea necessary is that you knowingly did it without the other person, the pictured person's consent. Sticking with the revenge porn, not the child pornography example. So it's an adult. So imagine that's the only requirement. And so, you could at least imagine that statute. I think that's what our statute says. No carve outs for attorneys, so it's a crime. So where would you land assuming that were true?
Well, I think I would land in the same place, I think, with respect to some of Judge McLeese's hypotheticals. Number one, that is not something that the attorney would be able to reveal under Rule 1.6, because it's not something that is likely to result in death or substantial bodily harm. But two, if for some reason
Right. I mean, imagine an enterprising prosecutor who knows that the client probably shared that photo with his attorney, decides to subpoena the attorney and call him in the trial and says, I did answer me this. Did he show you the picture? And that I'm going to tack a charge on for that.
And I think there would be an easier answer for us to say, you showed him the picture for the substantial purpose of getting legal advice of, do we have a sufficiency of the evidence claim?
So your answer is, if it's, I just want to make sure I understand the answer. If it is both for a substantial purpose of seeking legal advice and itself is a criminal act, then the privilege applies?
Well, I'm not conceding that it would be a criminal act, but I guess in your hypothetical, which is, I think, highly counterfactual.
I don't think it's I looked at the statute. I mean, but what about the example of, the Judge McLeese gave? I'm going to kill the prosecutor. What are my penalties going to be? That's clearly seeking legal advice, clearly a threat.
It is, and I think under the first piece of our test, it's seeking legal advice, but is it the type of communication that would be protected by the overarching values of the privilege? And that would be no.
Where are you getting that second step of this test? I mean, the two steps of the test that I see are, is it for the purpose of seeking legal advice? And if the answer is yes, well, then you're into the crime fraud exception. And I mean, that's Purcell says, they exhaust the category of potential attorney-client speech. And I think that's on par with a lot of the cases. So where is this? Is this the kind of thing we want to protect? I mean, I think that's generally answered by those two categories. Well, you ask, was it in pursuit of legal advice? And then you ask whether or not it advanced a crime. And after you ask those questions, I don't know that you ask a third question. And do I feel good about it? Do I sleep well, letting this go protected? And that's kind of sounds like what you're asking for.
That's not really what we're asking for, Judge. And I think there is some legal groundwork for the test as I'm trying to articulate it, probably not well. But if you look at the decisions such as Zolan and Fisher, it says that the privilege is important where it is necessary to achieve its purposes. And In Re PDS also seizes on that principle to say that we don't want to protect the privilege where the communication is an abuse of the privilege. And so we are looking at the end of the, and that's really why we have the crime fraud exception to begin with, right? But this is the unique situation that I think In Re PDS somewhat adverts to, where the communication itself is a crime.
So why isn't your answer to Judge McLeese's hypothetical that the first half of that, maybe it's because you don't want to go to that level of parsing, but why isn't your answer that the first half of the statement, the threat, which was unequivocal in the hypothetical and made and completed, that the communicative aspect of that threat was not seeking legal advice and the act. So therefore you have a communicative act, which is not privileged. And that the second half of the question, what is my penalty, might be privileged. And that
I think that's a very possible
from when determining admissibility, from breaking it down.
I think that, again, this all depends, and there is some syntax, and I know there's some disagreement about what degree do we want to rely on syntax. But I do think if a statement is made first that is deemed to be by the attorney a true threat, that's not protected. The second statement, if I really go through with this threat, what's going to happen to me, lawyer, that's protected because it's calling on legal advice. And I would say in terms of parsing, I don't think that the courts have issued any rule that is contrary to the need to parse. In fact, the entire premise of the crime fraud exception assumes that we're going to parse. And if you look at other contexts in the attorney-client privilege, in the civil realm, for example, parsing happens all the time. And so I
But
don't
there's no
think,
parsing in this case, right? I mean, everything comes in, all the, right?
the threatening statements come in, sure.
Well,
But the other things
well
that
beyond
Mr.
the threatening statements, it's all the communications that he has with his lawyer, you know.
Well, I don't
he's
think so. I don't
talking
think
about the
everything-
guns and he's got guns and, he's told me that he's a gun lover and, I mean, everything about the communication about in this case comes in at trial.
Came in with respect to whether or not it was a true threat. But to the extent that there were other communications that did not relate to the threat, for example, it wouldn't, and we're not
But
suggesting.
I'm just suggesting that as far as like applying the privilege, like if your point is the threat is unprivileged, all the other stuff around threat would seem to still be privileged, no? Or are you saying?
If it's not made for the purpose of legal advice, if the fact that, for example, an attorney makes an observation or the client tells the attorney, as in this case, I have a lot of guns. How's that related to the purpose of the legal advice? That's just a random comment. It's no different than saying, I have a great baseball card collection and it's worth $1 million.
Can
That's
you
not
say again,
privileged.
counsel, can you say again why you don't view this as a new exception? It seems very much like a new exception, the way you are describing it. There's a threat, doesn't matter. There's no flexibility. The severity, the context doesn't matter. That sounds like a new exception. I don't understand your description of it. And also, I wonder if you could respond to what Judge Deal was saying about whether this is categorical or not.
Well, Your Honor, we don't think we're carving out a new rule. We submit that we are applying the Wigmore test as this court's embraced it. And we're asking whether or not the statement and one of the significant purposes of the communication was to obtain legal assistance. Here, when there's a threat made, a true threat. Now, remember, I'm talking true threats. That's not made for the purpose of legal assistance.
No truth that threat ever is.
And the case law, which we've cited, and the commentators in our brief, which we've cited, have pretty uniformly agreed to that. I don't think this is a new rule. I think this has been out there all the time. The only new rule that's been articulated are the cases that the majority decisions relied on. And they are trying to forge a new realm, if you will, of the attorney-client privilege. So if you look at Boatwright, In re Grand Jury, and Purcell, all of those cases pretty squarely say, we're not applying the typical Wigmore test. We're saying that because we need breathing room, threats are okay. I mean, that's effectively what those courts have said. And we think that's wrong. We don't think that is appropriate, and we think it's an abuse of the attorney-client privilege. And none of those cases that the majority decision relied on even address the wealth of authority that says
The
that a
wealth of
threat.
authority that the government relies on really doesn't have much of analysis. I mean, doesn't address the animating principles of the attorney-client privilege and the desire to foster open communication. I mean, you just don't, it's not there.
It's because it never gets out of the gate. It is not a request for legal advice.
Well, it
There's not
leaves-
much to discuss.
It leaves, one could argue that understanding what the animating principles are informs how you understand what a request for legal advice is, and that it doesn't have to be a call and response request answer, that it could be more of a conversation and that it could include venting, right? And so, the weight of the authority that the government has just doesn't have a whole lot of analysis on it. So, I mean, we're operating with very little guiding authority. We've got a few cases on one side, and we've got some cases on the other side. I'm not sure how helpful that is to us.
Your Honor, we would submit that the wealth of authority and the fact that it is so obvious that a threat is not made for the significant purpose of getting legal advice speaks volumes standing alone. But put that aside. Let's talk about what is the purpose of the attorney-client privilege: to have good communication with lawyers and clients. If that's true, once we get to the point of a true threat being uttered, that's not something that the attorney-client relationship is meant to foster, period.
But it's meant to allow the attorney-client relationship for the attorney to be able to rectify that, right? To push back on it and try to stop it.
Most certainly.
And so one of the things I'd love to get your reaction to, going back to kind of also your Zolan and Fisher points and how we're looking at purposes. And with apologies to Mr. Day if I misstate your position on this, but I'd like to get your reaction to the idea that 1.6 is really a pressure valve. And so maybe it's that disclosure allows, without touching the attorney-client privilege, to deal with these concerns about safety or the court ordering you to do something. And if we viewed it that way and viewed it as ambiguous, whether something is seeking, whether the threat is seeking legal advice and a threat or just a threat on its own, don't you see incredible tension with some of the other attorney duties, like the one from the ethics rule 1.3, that a lawyer shall not intentionally prejudice or damage a client when it gets to this testimonial stage beyond the disclosure itself? And how would you resolve that?
Well, Your Honor, I think once the disclosure is made under Rule 1.6, there's already been, if I could put it differently, kind of a chill, if you want to say that, or a piercing of the absolute confidentiality veil, okay? There's already been something done by the attorney that is not completely consistent with what the client might want to happen. So that has already kind of happened with the 1.6 disclosure. And so I would submit that the additional change, if you will, in the relationship, once an attorney is called to testify, isn't really moving the needle that much, because the decision to basically have the threat reported, have the victim of the threat told about the threat, the client's gonna, not be too happy about that. So whether or not the attorney takes the stand, yes, I agree, that's not what any defense attorney wants to do, and it rarely happens. We're not endorsing that this should happen all the time. It's a rare circumstance, but I don't think that modicum or that additional quantum of chilling really should guide the court's decision here. In fact, I think the converse is a worse policy, because the defense policy in this case, as I understand it, is it's enough for the attorney to report under Rule 1.6, but if the attorney happens to be the only person who can testify to the threat, the defendant gets away with that threat. The victim's already been advised by the U.S. Marshals, presumably, that someone's threatened you. And so the purpose of the threat has been achieved with bells on, but no one's ever going to put the defendant on trial for that obstructive act and that threat. And that's not what the court should endorse. That's a free pass.
But there's been an opportunity to address some of the safety concerns of that.
There has been an opportunity to address the physical safety concerns. But Your Honor, I would stress that the entire reason we criminalize threats, it's not just for physical safety. It's that the fear that threats engender, the effect that the threat has on the hearer, as well as on the proposed victim. It affects how people are going to conduct themselves, how well an attorney might do her job if she's afraid. I mean, those are things that the court should really care about. And that's,
Sorry. go ahead.
No, so kind of, and I'll make this last question for me on this end. So academically interesting. This is fascinating. It's philosophically fascinating. We can have tons of discussion with it, and I'm sure attorneys will understand it very well, but it seems that this rule is particularly important in any articulation that a client can understand it, or there's this invisible tripwire referenced in the briefing that they can cross a line they don't necessarily know they're going to cross. And so how do we articulate it, and how can this law be explained in a way that lets a criminal defendant know where the line is? Because that seems really concerning, that you could just haphazardly walk off the cliff at any given point trying to express yourself to your attorney.
Your Honor, we think that this is not a trap for the unwary for a number of reasons. And I think this case illustrates why, okay? This is not just, as I think one of the briefs referred to as a serendipitous comment or, an ill-advised remark. These are remarks that are made after being told, you can't say that. That's not okay. And then you double down and say, no, I'm going to put a cap in that B. I mean, that's a threat. And so I think if we had to articulate the rule, we would say, if it's a true threat, that's not protected by the privilege, because that is not something that is appropriate to expect your attorney to hear, and certainly not appropriate to seek advice on how to achieve the threat. That's
And
not,
it
it's
sounds
outside
like
the scope of the
implicitly
privilege.
your view is that there must be a doubling down or something, even though you're saying a true threat is a true threat is a true threat. what I'm hearing in all of your answers is that as a practical matter, the attorney's going to say something. And when the person persists beyond that, do you think that's something that should be formally adopted, that given the sequence of events and how quick that happens, the attorney should push back in some way? And at the point that that pushback or some inquiry into the true nature of the threat occurs, then we're triggering 1.6, loss of confidentiality, et cetera.
Well, I don't know if I would frame a rule that would require a doubling down. I think I would frame the rule to basically say that when an attorney or when a client utters a true threat to the attorney that is disclosable under Rule 1.6, the attorney-client privilege does not protect that, and that the attorney can be called to testify if needed without violating the attorney-client privilege.
True threats, the threats that we want lawyers to know about so that they can redirect their clients. I mean, it seems like the government is positing a rule where a defendant has to regulate themselves, can't get too angry about what's going on. And you know, if they lose it, they lose their right to counsel in all regard, right? So you have to meet some sort of standards or criteria to get the benefit of the attorney-client privilege. And if you walk over the line, you've lost it, and you've lost the opportunity to work with your counsel to come back on the right side of the line. Why should that be the rule?
Well, Your Honor, the criminal threat statute is applicable to all of us, and it applies to people in all kinds of situations where they're angry and frustrated and everything else, not just for indigent criminal defendants. And the court has always recognized that there is something unique about threats, and that people are, I think, charged with understanding at some level that there's a line. And here, if you look at the Counterman case, you look at this court's decision in Young, that's why we have a threat statute. That's why it's been on the books at the common law forever, and that there is a line. So the question about, well, don't we want people to say threats to their attorneys so that they can stop a threat in its tracks from being consummated? Well, I think in a certain situation, an attorney could certainly try to intervene and try to have the person recant the threat, but short of a recantation of the threat in itself is a crime. And that there shouldn't be an exception for people who are in a difficult criminal case. And I think that has to be an equally applied law, because when people are talking to lawyers in many situations, whether or not it's a court-appointed lawyer, oftentimes people are fired up. You know, it could be a divorce, it could be an estate dispute, people fighting over money, people get fired up. But for everyone in our community, expect them to abide by certain norms. And those norms here were violated. And that is why the jury found that this individual committed these crimes, and this court should affirm the convictions.
Can I just ask you what, because I feel like you're about to wrap up, and I have one more
I'm
question for
trying to,
you.
Judge.
I'm sorry. You were also earlier saying that essentially that if we didn't waive the privilege in this instance, that we would be letting people get away with something. It seems to me that that happens all the time with attorney-client privilege, right? If I shoot someone and then walk into your office with the still smoking gun and say, I'd like you to represent me. Imagine you're not working for the government. And please help me. I just shot someone. I am armed. I am dangerous. I have just possibly killed someone, and our conversation is privileged, right? And nobody can use my confession against me, right?
That's correct. I agree. And that's a
you
patent crime.
You can litigate against, you can litigate for me, and you can get me off, and I can be completely protected, never convicted, acquitted of this crime, That's
attorney-client privilege
attorney-client privilege does.
It does, and it's in derogation of the truth, and that's why it is narrowly construed, because precisely for that reason, actually, because it is keeping relevant information from the fact finder, but generally speaking, the community is willing to accept that cost because we want people to have a fair trial and the ability to have someone to assist them through the process. But when someone utters a threat, that's a crime right there. And that's akin to,
And it's
is if you came into my,
it's completed as soon as I say it, and nothing that you do assists me in that crime, right?
it's using
So-
me as a lawyer to basically hear your threat. And that's an abuse of the attorney-client relationship. That's not what it's for. That's not what it's for.
So is the lawyer the victim?
It's one of the victims, potentially, yes, because if that threat, if I'm a defense lawyer or I'm a prosecutor, because prosecutors get threatened all the time, it does chill your diligence and time. It could. So it could threaten the attorney and say, whoa, this client, I don't want to deal with this. It has an effect on the hearer as well as the intended victim. And so
So you talked about norms too, and wouldn't you agree that generally speaking, people view attorneys like priests or confessors and psychiatrists, and whatnot? I can tell my lawyer anything, and this is confidential. And in fact, in this case, it's on the record that Mr. Moore waited for Ms. Guest to leave and tried to make sure that he was in a private setting with the attorney. Was there anything about that that triggered beyond the 3 months prior warning on kind of an objective sense that he would be saying something he shouldn't think is confidential at all?
well, I think that your confidence has to be reasonable. A reasonable defendant or a reasonable client has to understand that when I'm talking to my attorney, it is within the purpose of obtaining legal assistance and uttering threats. A reasonable person, because that's what the law presumes, would know that a criminal threat is not for legal assistance, and certainly it's not even permitted. It's potentially punishable. So that would be my answer. Your Honor, we
I know you
recognize.
took, we've taken a lot of your time, but I wanted to know, I know counsel for OAG may address this in his argument, but did you want to say anything about the crime fraud exception in connection with threats? I know Judge Steele may have asked opposing counsel about that earlier, and I'd just like to hear your views before you sit
Yep.
down.
Well, Your Honor, we have not really viewed this case within the crime fraud lens directly. We view it, and we've taken the language from In Re PDS in this regard, that ab initio, this statement is not protected because it is not, the statement itself is not made for the purpose of legal assistance at all. Ab initio, it's an abuse of the privilege. And so it's not like a crime fraud in the sense that, I'm having conversations with whether or not I want to, threaten a witness or whether or not I want to get somebody to lie and do we want to put that testimony on. That's a different thing. We're saying here, you don't even get to crime fraud. You don't even need to get to crime fraud because ab initio, this statement is not something, this communication is standing on its face, not protected because it's a crime.
And just to be clear, counsel, it's not just that the government hasn't pursued crime fraud, the government disavowed a crime fraud theory in Superior Court, right?
I don't
in the opposition-
believe we pressed it in Superior Court. And I think,
It's not just that you didn't press it, you affirmatively said, we're not arguing crime fraud in this case, in the most, on the opposition to the motion.
Judge, I'm not going to dispute you on that, but I will say that the purposes, and again, it seems almost incongruous to say that you can't use a lawyer to advance a crime or a fraud. That's what the crime fraud exception says, but you can use a lawyer to basically watch you commit a crime, hear you commit a crime. And that to me, using a lawyer for the purpose of committing a crime, which is what uttering threats to a lawyer is, that's not even remotely protected. And it's almost a fortiori that if you're going to exclude from the privileged crime fraud statements, a fortiori, these statements should not be protected. And I think that's what Judge Glickman's decision in Re PDS was somewhat adverting to, although not directly. I would argue that it's certainly consistent with our position. So, Your Honor, we recognize that these cases are difficult, but they're also rare, and that the rule that we're dealing with here is going to exist in a very small sliver of cases. But at the end of the day, the criminal law applies to everyone. Criminal threat statutes apply to everyone, whether or not you're an indigent criminal defendant or not. And we think for that reason that these convictions should be affirmed. Thank you.
Okay, I apologize, we haven't forgotten about you or the rebuttals, but we just need to take about a 5-minute recess. Okay, and we'll return shortly. Thank you.
All rise. All rise. This honorable court is back in session. Please be seated and come forward.
All right, thank you for your patience. Counsel, Mr. Phillips.
Good afternoon, and may it please the court, Graham Phillips on behalf of the District of Columbia. The parties' briefs and the arguments this morning, and especially a lot of the hypotheticals, I think have covered a lot of ground and might convey that this court is facing some kind of major legal ruling in this case. And I want to submit that that is not necessarily the way this court has to decide. I think this court can affirm based on a narrow fact and case-specific ruling that rests entirely on long-settled principles, that does not require this court to disturb any of its existing precedent, and that won't chill any attorney-client exchanges of the sort that we in the privilege really care about fostering. And the ruling is simply this, that Moore did not satisfy his burden, and it was his burden to show that when he threatened to shoot the prosecutor, his purpose in making those statements was to obtain legal advice or assistance about his case. The trial court found, as a matter of fact, that that was not his purpose. If that finding is upheld, it is dispositive under Wigmore's age-old test and any of the treatise's variations on that test, and there is no basis on which this court can say that that finding was clearly erroneous. To the contrary, it was eminently reasonable. And that is all the court has to say.
Well, I mean, it does answer, there's a predicate question of sort of what the level of analysis, when we're analyzing what is somebody's purpose in consulting with an attorney, there's kind of a battle between the parties here of, is that a statement by statement analysis? Is that a per consultation analysis? And what I'm hearing from you is sort of a statement by statement analysis, which does sound like a pretty major ruling. That the attorney-client privilege is, you parse it, by each statement that's uttered, and that seems pretty dramatic to me.
So I say a couple things about that, Your Honor. I think, well, first, there's no sort of parsing or separation required with respect to the June threats. The conversation from the jump was about threats. So I think that this issue only applies to the April conversation. And I think there's a wealth of authority that we've cited that says that privilege is not analyzed solely at the level of a particular document or conversation. And I think that would be a really extraordinary rule that would be so easily subject to abuse. And I think this case does not present sort of a couple of thorny questions. There's no need to sort of do any kind of strange sentence by sentence separation here, where the separation is sort of between the first portion of the April conversation, in which Mr. Harvey was sort of talking about what the prosecutor's role was. And then I think there's a pretty easy and clear separation between sort of once the threatening monologue begins. And I don't see.
When do you think that begins? Is that when Mr. Moore says how angry he is at the prosecutor, or where do you find the line of that easy separation?
I mean, I think where I understand the trial judge to essentially have drawn that separation, is essentially at line 13 on page 10 of the grand jury transcript. This is Appendix 91. Then he started saying, "Man, she keep effing with me. I'm going to shoot this bee. I'll F this bee up." He said it the first time, it was kind of shocking to me, and I just waved it off. Then he said it again. And I think that.
Can I just say that, I mean, if you found, I didn't find it at all clear where the trial court thought the line was. The trial court's ruling at the hearing on the in limine motion was to say, I think, if I'm recalling correctly, just the threats come in. Which suggests that the trial court was thinking of those threats, I guess, but didn't really indicate exactly what all came in. And what came in, not clear to me, all of it would have been, it's not entirely clear to me how much of a set of comments that have threatening content, how much of all of that is the threat, or that's murky to me as a legal matter. But I also had no idea what the trial court thought that meant exactly. So I'm not quite sure what gives you the confidence that you think is clear what the trial court thought that line was.
So I don't mean to suggest that the trial court identified the line that I'm identifying, but I mean the literal line. What I understood the trial court ruling to say is that there's this initial portion where Mr. Harvey is trying to explain, no, this is the prosecutor's role. This is her role, and that aspect was privileged.
Can I ask you just, so, I mean, it just seems to me that there is parsing implicit in your approach. And just again, back to the hypotheticals, for which I apologize, I guess, but if what had happened here was that the in-court proceeding on the first day happened as it did, and Mr. Harvey came out and he was obviously angry, and he said, I'm really, really angry about that ruling. And that's all he said. And Mr. Harvey kind of didn't really engage with that and said, okay, let's talk about what's going to happen next. Is it your view that would be in or would be out or would depend on a hearing at which people would take testimony and draw inferences of fact?
So I do think the test is about the mental state of the person who's doing the communication. I think that's what Wigmore says. I think that's what all the treatises say, that it is about the mental state. And so I do think in many, many cases, it will come down to a question of fact. Of course, I think there are many, there are many types of things people would say that I think everyone would easily agree about, and so they won't be disputed questions.
So on this one, you think a reasonable, depending on what the assuming it's the defendant's burden and there's no presumption at play, which is another legal issue that the parties seem to be disputing. But assuming there's no presumption at play, your view is if the government subpoenaed the defense attorney, let's say later the prosecutor was actually shot at, and that the government thought that it was Mr. Moore who had done it, and they wanted to prove that it was Mr. Moore who had done it, and they thought, here's a way we could try to prove that. Let's see whether during conversations with his lawyer, Mr. Moore expressed anger. So they subpoena the lawyer and they ask the question, or let's assume there's process. So Mr. Moore is involved in this question. There's an in limine hearing about whether the lawyer can be asked the question and compelled to answer the question of whether during in the conversation in the hall that I'm hypothesizing, Mr. Moore expressed anger. Your view would be that the way that would have to work is Mr. Moore would get on the stand, he'd have the burden, and he would say, here's why I said what I said. And the fact finder would assess that, consider the circumstances, what other evidence, the defense attorney or whoever else was testifying would adduce, and would make a determination of fact as to whether a significant purpose of that expression of anger was in the hope of getting some kind of legal advice from Mr. Harvey. Is that how you think it would spin out?
So I don't want to dodge the hypothetical, but I do want to acknowledge that I think it raises some of the difficult sort of procedural, what I'll call procedural questions about how this type of issue would unfold in a case where you do not already have the communication in front of you in the way that we do here. Because I acknowledge of seeming an oddity about this case that Judge Easterly raised. And I'll just flag that I think that potential oddity about this particular case is yet another reason to decide it on its particular facts and procedural history. And I think it's.
So I got that procedural point, but then back to assuming that's the way the procedure spun out, what your answer would be if that's how it should go, or you think something different?
Yeah, I mean, I think you would do. I think it would make sense to try to do everything you can to understand the context before sort of getting to those types of questions. And I think that the sort of procedural threshold for demanding that kind of testimony where the client or the attorney has said, no, I think this, I think this conversation was privileged, and let me tell you the circumstances around it that give you a strong reason to think it was. But then if for some reason you really thought
What does defense counsel say? Right? I mean, they think the conversation is privileged. What?
Right. So I think they would say this was a conversation that was about
the case.
About the case, and it was for the purpose of giving legal advice. And then I think the burden would be on the government to like have some kind of, this is analogous to the situation in the crime fraud exception, some kind of threshold of why do you on what basis do you think that's not true, and that actually there was something unprivileged within there.
I mean, I'm glad to hear that you think that the burden on the defense is so low, right? Just to say, I was talking to my client and it was related to this case. It's privileged in my view, right? Like, I mean, that reveals nothing. And so that sounds about right to me. But I'm sort of wondering why, that doesn't sound like much of a burden then, and seems to really kind of flip the burden onto the government, but you said the burden's on the defense. So I'm a little confused.
Yeah, and I want to stress that I think these are thorny issues about what you do in this type of setup where you do not yet actually know the contents of the conversation. And I do not think this court needs to or should sort of try to abstractly opine about that in a case where it's not presented. But I think you would look to the similar sorts of inquiries that happen in the civil context. People produce documents and assert on a privilege log that it's privileged for this or that reason, and then to sort of get behind that and require in-camera review by the judge, the opposing party has to make a degree of showing that there's some reason to think that there's unprivileged materials within that communication.
I take your point that Judge Isco says this communication is not for the purpose of seeking legal advice, but he never says what he thinks the purpose of it was. Do you have a view? I mean, presumably you'd agree with me that Mr. Moore would not have been thrilled that his counsel decided to share this threat with the court or with the prosecuting attorney, which makes, I haven't revisited the obstruction statute, but it seems a little odd to me that it ends in an obstruction prosecution when I think most naturally you would think, well, there's no way he wanted that to go past his attorney. He didn't mean to obstruct the prosecutor, but maybe any threat counts. So, I mean, what do you understand his purpose to be? I mean, isn't the only real possibility sort of a venting purpose? Do you think it was a confession?
Right. I don't dispute that it was anger and that it was anger that was causally connected to his unhappiness about the case. But I think people all the time issue threats where their purpose is to express their hatred or anger or something like that. I don't think that's unusual.
I don't think that's unusual in the context of a case. I don't think that's so unusual in trying to figure out what's relevant to, I mean, maybe this case is an extreme, but this witness, I can't stand him. They've had it out for me forever. We have this long beef that's been going on for years. All that might provide fodder for cross-examination for a defense counsel, even though the purpose was, well, actually, I'm not a lawyer myself, the client might say. I didn't really think about exactly how my lawyer would use it, but I'm venting, I'm kind of letting them know everything I know, and maybe it'll come in handy, and maybe I'll just get this stuff off my chest.
Well, I do want to concede that we are not suggesting that only disclosures that the client knows are in fact legally relevant. That's not the test we're embracing. I acknowledge that if the client shares facts, shares some background that they think is useful to their lawyer, but they're wrong, they don't understand the law. I agree that's still made with the relevant purpose that gets you into the privilege.
So can I ask you to maybe walk through one more time what you said would be a narrow resolution of this case on the facts that we have? You said, what are the steps? I wasn't sure whether you were looking at 1.6C, whether you were looking at the case law and common law surrounding our privilege. Can you sort of walk me through that?
Sure. So I think what's in dispute here is what we might call element number 3 of the Wigmore test. It's also called germaneness or the incidence requirement. And I think that is a question about the state of mind of the client when they make the communication that's in question. And the required state of mind is that it be for the purpose of obtaining legal advice, and that the trial court here found as a factual matter that was not Mr. Moore's purpose, and that I don't see a basis on which this court can call that factual finding clearly erroneous. I think that can be the end of the analysis, and the court doesn't need to say anything categorical about threats. You don't need to, that doesn't deviate from any existing precedent of this court. It doesn't sort of embroil you in sort of tricky and unknowable questions about, chilling versus harm.
How do we know that was a factual finding subject to clearly erroneous review? I mean, Mr. Moore didn't testify in a motion in limine hearing, did he, about his purpose?
He did not. He had the opportunity to, but he did not.
I mean, it seemed like more of a legal conclusion that necessarily this type of statement could not be relating to a purpose, to the purpose of seeking legal advice.
I mean, that's not how the trial judge says, I do not find that these particular communications were made for the purpose of seeking legal advice.
Well, I mean, courts use find and find all the time.
That's right. But I mean, he says it's these particular communications. I don't think the trial judge ever articulates some kind of rule that true threats are never made for the purpose of seeking legal advice.
Did the trial court, in making that word purpose, make clear whether it was using that term in its subjective sense? That is to say, the client had in mind, here is why I am asking this question. It was actually consciously thinking that. Or in a more objective sense, which sometimes the term is used to mean it's not, if something is not for the purpose of it, if it's not well designed to, it isn't kind of logically functioning as that. Is it clear from the trial court was making like a finding of historical fact about the subjective mental state of Mr. Moore?
I don't recall that the trial court ever says sort of subjective or some variation of that word. I mean, I do think that.
I mean, I'm looking at appendix 112. To me, the nature of the communication in question here, threatening the prosecutor and stating repeatedly what he's going to do is not related to the legal advice about how to proceed at trial. I mean, that it seems like the latter. He's not talking about Mr. Moore's subjective thoughts. He's talking about sort of as a legal matter, a threat can't be legal advice, seeking legal advice.
I mean, I think the trial judge sort of said, because this hearing kind of went back and forth over many iterations, we don't have like the one clear occasion where the judge issues the ruling, but repeatedly talks about whether their purpose was. And I think the best places for this are on transcript pages 25, 41, and 43. I just think those are the clearest articulations of finding that about the purpose of these communications. And certainly,
assume for a moment there is a distinction between kind of making a finding of what was in Mr. Moore's mind subjectively about why he was saying what he said, and some more objective inquiry about what the logical relationship or connection is between what Mr. Moore said and legal advice. If, to the extent we're wondering about the second of those topics, would you think that's a question of law? Is there a logical relationship between them? Or would you think of that as really a question of historical fact that would be reviewed deferentially?
well, there could be a kind of objective element that could shade into a question of law. I mean, we would endorse in our brief cites the sort of version of the germaneness test that I think originally comes from the ALI's model code, but then is endorsed by federal practice and procedure, which says that communication is germane when the client or lawyer reasonably believed the communication to be relevant to the seeking or rendering of the lawyer's legal service in a professional capacity.
And you said or. So either the lawyer, you'd have to figure out the perspectives of both the lawyer and, so you'd have to look at both Mr. Harvey's thinking and.
No, I think it's key to who is the speaker in the particular factual circumstance you're looking at.
Then it'd be for giving or receiving.
Exactly, yes.
Got it.
And so I do think that has an element of reasonably believed. And so I think you could have cases that are and I would say that this is one where it is not a reasonable belief that a true threat of violence in this context could be relevant to obtaining legal advice on the case. So that is the example that federal practice and procedure gives after saying that the determinative question is the purpose of the person communicating. It then says, this follows from the policy of the privilege. There is no reason to provide an incentive for clients to make statements such as threats to kill the lawyer that the client could not reasonably believe facilitate the rendition of services.
The threat to kill the lawyer, right? I mean, if the policy of the privilege is to promote the attorney-client relationship, then maybe the threat to kill the lawyer falls outside of that. But threats in toto, all of them, regardless of context, I mean.
Well, I
Federal
certainly,
practice and procedure doesn't say that, right?
that's right, but I'm not willing to endorse the notion that threatening to kill the prosecutor is a reasonable way of obtaining legal services. And I don't think it's, maybe I should shift there into the question of chilling, because I think the only thing that seems to be a concern on the other side is that if that's your rule, we will be chilling some amount of useful, disclosures from the client that we need them to make to provide.
Because the threat doesn't stand alone. I mean, it could, right? Hypothetically, it could. It could be just a cold-blooded walk up to your lawyer, say, I'm gonna kill this barista at Starbucks this morning because she screwed up my latte order, and walk away, right? Hard to say that that is a request for legal advice, right? But a threat could, as in this case, be both a threat and a communication about how one feels, right? And so Professor Winklereed, if I'm pronouncing his name correctly, talks about how facts come with feelings, right? And so, this might be a case where facts come with feelings about the facts, about facts that you don't like, about facts that you think are screwing up your life, and come with messy emotions. And I'm just trying to understand why the government doesn't think that those communications should be happening between a client and a lawyer, or why the government thinks that there's a limit to how much can be communicated, right? That the client can only communicate so much, and beyond that, they're on their own because those feelings are too strong and can't be communicated within the attorney-client relationship, is essentially what I'm hearing the government say.
There is no limit to how angrily a client can seek legal advice, how angrily they can relay the facts of their case. So we're not advocating for a rule that is triggered by some level of emotion. The question is about whether the nature, so both
With the anger comes the ability to verbalize, right? With the anger level comes the inability to regulate, the inability to pose it as I feel this way, as opposed to just the eruption, right?
Well, Your Honor, if we're imagining that this is occurring in places, in circumstances where people are unable to regulate themselves, then all these questions.
Regulate themselves with their lawyer, right? Because mind you, in this case, Mr. Moore holds it together in court and says, I need to go talk to my lawyer. And then with his lawyer, lets it all hang out, much like perhaps one of my teenage children going to school, keeping it all together, and then coming home and falling apart with me, right? So that's what the lawyer is there for.
So I guess one, I'm on the question of chilling, I think there are a couple of points. I just do not find it plausible that if the rule that this court sets out is that a true threat of violence is not going to be privileged, that is, and that people actually know about that and calibrate their conversations accordingly, which is the whole premise of this line of argument.
Well, we've already discussed in prior hypotheticals that you could couch it as a question, right? Like, I would like your best advice as to how I could kill the prosecutor.
So it's a hard to imagine hypothetical, but if you had someone, maybe like someone from a totally different culture, who genuinely asks that because they don't, and they really are seeking advice, then I think that would be privileged. But if it is a threat and is not made for the purpose of legal advice, then it's not privileged, whether expressed extremely angrily or in sort of cold blood. Either way, I think it would fall outside the privilege. And part of the reason that I think came up earlier is that a threat is itself harmful, and the types of threats where this is actually going to arise are threats that are so serious that the defense counsel feels that they have to disclose them. So I don't think we're worried about casual, I could kill her. Because the lawyer is gonna know that that is not a real threat that rises to the level where they even can ethically disclose that, let alone want to. So we're talking about this narrow class of serious enough threats that the lawyer feels that they should disclose them. And those very serious threats come with very serious harms. And I think that distinguishes them from the types of things that I think that the In re PDS case is thinking about, where, if you propose to your lawyer, even sort of knowing that it's illegal, like, I'm thinking about cheating on my taxes next year, that is not intrinsically harmful in the way that a threat is. And that is why we don't make that itself a crime the way that a threat is itself a crime. Unless the court has any further questions, I'd be happy to end there.
All right, thank you. Thank you, counsel. Mr. Day, I think we reserved some time for rebuttal for you.
Thank you. And I was going to allow the PDS 2 minutes of my 5 of rebuttal. So the government said that there should be no privilege for what they call true threats, that the lawyer under Rule 1.6 believes necessary to make a disclosure. This turns hundreds of years of precedent on its head. This places the privilege with the attorney, not the client. And I think the context that the majority in this opinion put in this case, that this is a court-appointed attorney. So if the court appoints you a sensitive attorney who is more prone to reporting threats.
That only relates to 1.6 and the attorney's decision to disclose under 1.6. Before you get to an evidentiary stage and the breaching of the privilege, it's the client that invokes the privilege or not, and it's the court that determines whether the evidence is admissible or not.
I would agree with that, but I'm saying this is the trap that the government is falling into. They say that it doesn't apply to a true threat where the attorney invokes Rule 1.6 and making the disclosure. And if the attorney makes that disclosure, then it's not privileged. And they are placing the privilege in the hands of the attorney. And in this case, it's an attorney that the client didn't even choose. So if you have a sensitive
Well,
attorney.
I don't know if the government made the argument that once the attorney has made the disclosure that, we've explored this question, but that it's thereafter not privileged simply by virtue of the fact of the disclosure. But I agree that's a tough question.
I heard it from both. I heard it from the US that if it's a true threat, that the attorney then makes a disclosure in 1.6, it's not privileged. And then the district said, well, if keep in mind, this is where the lawyer feels they have a need to disclose. So again, both of them are putting this privilege in the hands of the attorney. So if you have a sensitive attorney who makes the disclosure, it's not privileged under the rule they're arguing. That's why their rule is not workable. And if you have a more insensitive attorney who kind of just shrugs it off, then it is privileged. And that can't be the rule. That can't be the way this works. And as far as how this communication related to the representation, I believe they've stated the rule is that the purpose of the communication has to be for representation. That's not what the Wigmore rule says. It has to be related to the purpose. And the question is how closely related it needs to be. And in this case, we have a defendant who comes out of the courtroom and is mad, and he's talking about the facts of this case and the pretrial release and intertwines that with a threat. He says, well, on April 1, he says, if she keeps messing with me, I'm going to shoot her. And in June, he says, if she causes me to lose my job, I'm going to bust a cap on that bitch, whatever he said. An attorney can take this and say, oh my God, I didn't realize that this was so important to my client. I didn't realize that this job situation was going on. I didn't know the consequences. Let me go back in there and have the judge recall the case, like Mr. Harvey had for a different purpose. Let me have the case recalled and explain to the judge that he's got this job situation. He's going to lose the job. Mr. Moore should not have to be able to regulate himself to be able to get that kind of representation. He should not have to be able to go out and say, hey, this could cause me to lose my job. And if I lose my job, I'm going to regret what I do if I lose my job. So attorney, I really need you to go back in there. If you could please recall the case. He should not have to do that. These are highly emotional situations. These are clients who cannot necessarily, in the heat of the moment, to regulate them, and we should allow a free and open communication. And I think the government said that we don't have a lot of case law because, well, they use discretion in what to prosecute. And I would say it's more that attorneys are reluctant to make these kinds of disclosures. And the modern view is to allow breathing room for a client to express emotion and the emotions that come along with these types of cases. And not discourage the attorneys from making these disclosures or from cutting off the communication. Say, I don't want to hear anything that you have to say because you're about to say something that I'm going to regret hearing. This case allows this court to adopt a more modern view and lead the way along with Maryland, Massachusetts, and Kansas and their cases, which allow breathing room for clients to communicate with their attorney and even to say things that might otherwise be improper, but to
A
keep
more
it privileged.
modern view would be an extension of our current rule.
I would say it's an interpretation in this context. As far as, I think we're still applying the same rule. Does it relate to the representation? Yes, it does, loosely viewed. I don't think we're upending anything. Thank you.
Thank you. All right, Mr. Collins?
Thank you, Your Honors. If I could, I just wanted to address briefly the government's proposal or the threats exception argument and the completed crime aspect of it. There's been a lot of discussion about whether it's a new rule, and if it's a new rule, is it in contradiction to NRAPDS? We think so. We think yes on both accounts. And in those regards, we would say, and Judge Deal, I think, touched on this in one of the questions that he asked, in terms of how this constituted obstruction, but obstruction, as Your Honors know, is a crime that requires an endeavor, not necessarily the completion of an act. And if a lawyer says, if a client comes to his lawyer and says, I want to bribe this juror, and the lawyer shuts it down, those are circumstances which, under fair interpretation, NRAPDS would say that is not subject to the crime fraud exception and would not be subject to an exception to the attorney-client privilege. But those are circumstances under which fair application of the government's rule, that is not, the privilege doesn't apply. And we understand that this court is en banc, but we think that's a definite tension with the case law. And moving on, it just seems in general, the government's asking for a very broad rule and saying, don't worry about its application because it will be narrow inevitably. And we submit in a world of constant surveillance, particularly in the courthouse, where we, by necessity, confer with our clients. Even these gestures can be the basis for an inquiry, a breach of the attorney-client relationship, and all kinds of mischief that the Massachusetts Supreme Court very wisely has said. This alone, the inquiry into the grand jury inquiry into what statements were made and what were the context for these gestures, that is enough to chill the kind of attorney-client collaboration that we want and the kind of advisory relationship that we want our lawyers to have with their clients. And final point, Your Honors, we think Rule 1.6 has been mentioned a lot, 1.6C. The underlying rationale for that rule is preventing injury, and not just any injury, but serious kinds. The exception that's being advocated, as I understand it, is about prosecuting crimes. And we've talked about whether crimes are bad, we want to discourage them, we don't want to create a culture of immunity. But Swidler and Berlin, I think, is very instructive on this particular issue and acknowledging these are statements that may not be made in the absence of an attorney-client relationship. And if you don't have the statement, you do not have the crime. So this culture of impunity argument, I think, is entirely misplaced. But if there are no further questions, we would ask Your Honors to reverse.
Great, thank you. All right, the court would like to thank counsel and parties and the amicus on both sides for your briefs and your arguments today, and we'll stand adjourned at this time. Thank you.
All right. This court is now adjourned.